pledge, please. Okay, thank you. We've got, of course, this is our policy committee meeting of the whole. So it's a less formal agenda, less formal setup that we've got. But of course, because we've got the whole group together, it's a public meeting and we have call to the public available. And we have 2 cards tonight. Mr. Jason Schaefer.
How you guys doing tonight? As you guys have heard, over and over, we've been asking for our bus stop back. My wife's going to follow up with some things. Anyways, it's been a long process. As you guys know, we've been involved with the school for a long, long time. So I was just a little taken back. One thing I did want to point out, the email Chuck from December 5th, December 6th, I still have not got a response on that. And I was a little taken back by after my comment, and I walked away, that I actually heard someone say, I don't know what else to say about that. And I'm just kind of curious why, you know, there's really nothing getting said about that. So I got that, and my wife's going to follow up. Luckily, I was able to drive her up here tonight, so we made it. Thanks.
Thank you, Mr. Schaefer. Mrs. Schaefer.
I'm going to try and stay within my 3 minutes, but I was emailed an email at 11 p.m. last night from one of the board members wanting some answers. So I'm going to try and answer those for you guys. First, I was a little thrown back by the email. I feel like I'm being intimidated to not speak here, with comments of, if you choose to speak, approximately 150 days after I first spoke, per what reported, please provide those answers. So am I supposed to speak or not supposed to speak if I have the answers? Luckily, I think I have all the answers. I also feel when kids are picked on in school, people whisper, make snark little comments. We all know what a snark comment is. To end an email to me, the person that does not like to drive in the snow, and that's a big issue with January and February, March's driving my son to school situation, to end an email with, safe travels. Perhaps we won't see you tomorrow, unfortunately, as I know you don't drive with snow on the roads. To me, that's a snark comment. That's bullying. But that's just me. So I will move on to the questions. Questions that were asked. 1, in the email, it states that the bus stop at Mack and Fawcett and the stop at Fawcett and Granger, it states a stop will not be created. A stop will not be created for a school of choice student. Well, if you guys look back on all those emails I gave you on 10/6 from Julie Brown, it's saying it won't be created, but it didn't need to be created because it was always there. It's always been there. It was removed on 10/6. So my facts are correct. There is an in-student district. Didn't want to use names, but since it's brought to that, 5th grade teacher, Stacy French, has a 5th grade student that lives on Granger. So there's always been a stop at Granger and given to my student for till October 6th. That was my son's bus stop. It was removed. So to say create a new stop is inaccurate by the board member. Also on 10/21, Chuck Hughes also states, the Granger stop is no longer programmed. It was removed after given to me. So again, it was a stop. So there's the answer to that question of, or statement to him saying that I was inaccurate, that those stops are not. The Mack and Fawcett stop, I didn't know the answer to that. I went based off Chuck's map in his office, which I don't have unless Chuck wants to bring it in. You can see the little X's that he sends. It shows that there's somebody right there at Mack and Fawcett is where I come up with there's a stop there. But regarding that issue, he also stated that he drove by the stop, that it was given to me now on Allen Road, stating that he drove by and only saw 3 people at the stop. The stop that I'm stating, there's probably approximately 15 people at this stop, and I feel it's unsafe to be on the side of the road with 15 different other parents putting their kids on and off these buses. The fact is he only counted the students that were getting on the Farms Intermediate bus. There's 2 buses that stop at that stop at the same time within a 10-minute difference, which is the Village. The Village has 7 cars. The Farms has 5 registered, which I'm pretty sure y'all can check this out through transportation. 5 registered for Farms and about 5 to 7 registered for Village, which makes 10 to 15 cars at that stop, not 3. So there's the second answer. He also stated in the email that I claimed there was fights at the bus stop between students, which I do record all of our meetings individually or publicly. So I do have a recording that states that there was a conflict between a parent and a nearby person that lives by that stop. So like the neighbor must have had an issue. I wasn't there. I don't know 100% the facts. I can find them out. But since I only got the email at 11 o'clock last night, it was hard to go back and confirm what I've said. But to my understanding, what was told to me by another out-of-district parent that used to use that stop, there was a conflict with the person that lived next door or somewhere within that stop range that was having a discussion or argument with the parents about all the parking. Hence, we go back to the 10 to 15 different cars. If I was the neighbor, I'd probably be a little mad too. So there's my comment to that he asked for an answer for. What was the other thing? Off the top of my head, running out of minutes. I don't know what else the questions were, but I think that makes a good a point too. So far, the email that was sent to me again at 11 p.m. last night, suggesting that if I choose to speak, I probably should have some answers, so I tried to have as many as I could. And the snarky comment, he knows who he is. I didn't appreciate it. It felt a little bullied. If somebody was to say that to my kid in school, I'd be coming to the principal and saying, snarky comments are being made at my kid. I've had kids had snarky comments made at them, and to me that was a very childish, snarky comment. And I know it was snarky comment because it was the last sentence in his email, other than his name. So if you guys are trying to shut me down from speaking, I will not, because I will keep trying to prove the point with the emails, with the lies, with the recordings. I collect it all. This is why I do nothing in person, individually, because I like to record it all, but I was not caught off guard. I have my recording on hand at all times now. So if anybody wants to go over that recording of the discussion to know that this is inaccurate email sent to me, stating that I said there was fights between students, is wrong. But I will not be bullied by the board. I am a Hartland community member, whether I live in the district or not. I will not be shut down, shut up, and pushed away by somebody trying to bully me. I'm not going to let down for my kid. I will not let my kid down. And this isn't about the stop that Hartland Community Schools told the the state representative when he called. The school told the representative, the reason my son doesn't have a bus is because this is a private property issue. Since when have we talked about the private property issue? My bus was removed from my sister-in-law's place at Hardy Farms after 14 years. Disappointing situation. We've moved on from that. We went from Chuck's offer to the corner of Latson and Fawcett, which is not Hardy Farms property. We went to Mack and Fawcett. We went to Granger. We're not discussing Hardy Farms property issue anymore. That's done and over. We're discussing the fact that there's no reason my son cannot be offered a stop at Granger or a corner or any of those because I was already offered it. At one point, I was using it. So for them to tell the state representative that's what our problem is here, that's incorrect, whoever told him that. That is not the problem. The problem is the lies, the email lies from at least 3 to 4 different Hartland District employees.
Mrs. Schaefer, I've given you a lot of grace here. I need to ask you to wrap it up.
Thank you.
Okay, moving on. As I mentioned, this is a less formal format to hopefully encourage some more discussion around each of these policies that we've got that have been brought forward to us. Any questions that you didn't have the chance to ask the admin team or Chuck since the packet went out? Obviously, Chuck is here. He can answer questions. We can direct questions to him, or he can defer to his team as appropriate. As with our last policy committee meeting, I'd like to propose that we set an end time for tonight. I've taken the liberty with Renee and Chuck's help to slightly reorder the policies from the original packet that went out so that we could prioritize the discussion in case we run short on time. And I think I was able to tag everybody to ask if they would be game to consider setting a time limit as we did before. We're about, 12 minutes in. I think last time we set an end time for 9 o'clock. How does that feel for everybody? Do you want to aim earlier? You want to go longer? Any thoughts?
Can I ask what the new order would be?
Yeah, sure. It's just, it's on the agenda. So we kept the postponed policies first because those have been lingering out there the longest. So those 3 policies, 2266, 5517, and 2210, all stay the same. We moved up the ethics policies ahead of the new communication policy. And then we also brought up the employment of professional staff, 3120, we brought that up from the bottom. The 1410 policies are just related to decision item and action item that we'll have on our February agenda. So if we had to, we could address those at that meeting. So I figured that would probably be best to put those last.
Sounds good.
So just a slight change to the order. So we'll shoot for 9 o'clock?
Yes.
Okay, and obviously, hopefully we can hit all of these. I think we lucked out last time because we had postponed a couple. I think that saved us some time, but we ended up on time last time. So hopefully we have the same luck here. All right, so having said all that, our first one up is 2266, non-discrimination on the basis of sex in education programs or activities. This is a revised policy. As a refresher, this policy was postponed from our November 3rd policy meeting. And as a refresher, I'm just gonna read why Neola brought that policy forward, just to give some additional context. A revision to this policy and AG is necessary because of the June 23rd, 2025, the National Incident-Based Reporting System, NIBRS, definition of fondling changed. The term is officially criminal sexual contact. The terms sexual orientation and gender identity have been retained in the parenthetical definition of sex in the policy since these protections have been required by the Michigan Elliott-Larsen Civil Rights Act. Neola recommends that we discuss this issue with legal counsel before deciding to delete the language, which that has since happened since this meeting. It's critical that you consult with your legal counsel if a situation arises involving allegation or discrimination or harassment based on sexual orientation or gender identity. And then in addition, the location, the office, just a technical change, the Office of the Civil Rights has changed to a different address. So that was a little bit of context from Neola. Since that meeting, Mr. Scott has provided some proposed new language and edits. The district received guidance from council, as I mentioned, regarding the proposed changes and formulated some recommendations for the board to consider. All of that was recently sent out to the board for review. In addition, Mr. Scott followed up this morning with an email containing Brighton's version of this policy, which is through Thrun, for additional reference and consideration. I think that tees everything up to get us from where we left off. So, Mr. Scott, would you like to take it from there?
Yeah, that'd be great. Before we get started on this, I'd like to move that we waive attorney-client privilege on the communication received from Thune Law Firm January 5th, 2026, in response to my questions and revisions.
Okay, so I have a motion on the table to waive privilege.
Second.
To discuss the communication from Thrun. How did you word that?
Yeah, the attorney-client privilege communication to Superintendent Hughes dated January 5th, 2026. The memo title is Proposed Board Policy Updates and Revisions.
I'm sorry, tell me the date again.
January 5th.
And read the title for me.
Proposed Board Policy Updates and Revisions.
Proposed board policy updates and revisions. Okay, so the motion on the table brought forward by Mr. Scott, and that was seconded by Mr. Gogoleski,
Yes.
to waive attorney-client privilege to discuss the communication from Thrun to Mr. Hughes dated January 5th, 2026, entitled Proposed Board Policy Updates and Revisions.
Yeah, and the idea is not that it become a discussion item, just that during the course of our discussion, we can openly discuss what's in the memo without worrying about crossing any lines.
Understood, understood. Any further discussion? Okay.
Sorry, I had a question. So if the board chooses not to, I guess what are the constraints around? Because I know I do have some questions about some of the items that were in there. So how do we,
If we chose not to, as I understand, we would not be able to refer directly to that communication. I think we would still be able to utilize the administration's recommendations, which were in part based on that attorney-client communication. But if we don't refer to it directly, quote it verbatim, then we would still, I believe, be within the guidelines.
okay, yeah, I mean, for me personally, I think there's a lot of stuff in here that makes sense for us to talk about. So I do hope that the board will make it a little less awkward trying to navigate around it. I appreciate it's not going to become the topic of our policy discussion, but I do think there's some pertinent items in there that we should be able to speak about.
Any other discussion? Okay, hearing none. The motion on the table brought forward by Mr. Scott, seconded by Mr. Gogoleski. Motion to waive attorney-client privilege to discuss the communication from Thrun to Mr. Hughes dated January 5th, 2026, titled Proposed Board Policy Updates and Revisions. Mr. Gogoleski.
Yes.
Mr. Campbell.
Yes.
Mrs. Shaw.
Yes.
Mr. Keller.
Yes.
Mr. Scott.
Yes.
Ms. Custodio.
Yes.
And I'm a yes. Thank you for bringing that up.
All right, so I had three main points that I had emailed out on this policy. The first one being the inclusion of gender identity and sexual orientation in the first paragraph of the policy, which, as I stated at the last meeting, was against the current Title IX regulations. I know there was some pushback at that time. I've continued to communicate with the board. Thrun has given their input. It sounds to me at this point that most of the board is on board with removing gender identity and sexual orientation from the policy. I don't know if we can get an official vote on that, but if that's where everybody's at, it'll save me 2 pages of prepared comments, because the response I got today from my email with Brighton's policy was that administration was on board and some others were on board. So,
I concur.
all right. So if that's the case, we'll save everybody some time. So I'll get to my next 2 points that I had some concerns with. Number 1 was parental notification, and number 2 was law enforcement communication. So what I have to say here with Title IX mirrors a lot of what is in the bullying policy too. And as far as parental notification goes, Thrun and administration have brought up that we do have some basic parental notification in our current policy. And that is partially true, although the section is written incomprehensible. It has a lot of typos and grammatical errors. I'm sure we can fix that between now and next time. But I want to make it clear that my recommendation is to make sure that the parents of both parties are notified and given an opportunity to participate and understand the resolution process. I don't believe both parties are currently involved in there. I think the whole point of my recommendation has been missed based on the administration recommendation. My point is not merely a quick notification when a complaint is made. It is the inclusion of parents in the process. And that seems to be missing from the current notification. I believe this is best for everyone. I want parents to know which disciplinary sanctions have been cast down. I want them informed. I want them to receive copies of notifications, determinations, appeal rights, et cetera. So I think that's really important that we keep the language that I had included. If we need to tweak it a little bit, I'm fine with that. If we want to remove anything referencing sexual orientation, gender identity, since that's been removed from the policy, I'm fine with that. But we need to keep parents informed in the processes. Next was my concerns with the law enforcement notification. I want to make it clear, we are not police. We are not the district attorney or prosecutors. We're not defense attorneys. We are neither judge nor jury. The Title IX processes operate completely separate from legal proceedings. They do not replace them. And I think that's really key to remember here, especially since our own legal firm and administration are pushing for the use of what they call quote unquote discretion in getting law enforcement involved. If there's any doubt about the potential of a crime being committed, we need to report to law enforcement, period, end of story. First of all, I want to point out that the mandatory enforcement language I have proposed for our Title IX policy is legal according to Thrun's memo. I'd further like to point out that if you look at the Brighton policy, which I sent everybody this morning, written by Thrun, there's a whole paragraph in here about notifying law enforcement. So it seems backwards that we would somehow get some advice that we don't need to do that. Refusing to encourage employees to notify law enforcement about potential sex crime and giving one person in the central office all of the quote-unquote discretion on criminal reporting puts us in a really bad position, especially given this district's history of delayed reporting to law enforcement. The argument from administration and the legal against adding the mandatory reporting language of sex crimes in policy 2266, which we're reviewing now, is that it's duplicative, but it's not. Policy 8462, which Thrun refers to in their memo, applies to child abuse and neglect and actually requires teachers to report abuse to administrators, not to law enforcement. That's probably something else we should look into because that's not in compliance with current state law. They also refer to policy 5517, mandatory reporting to law enforcement, but that only applies to employees who directly observe criminal harassment. So there are criminal offenses which staff can be made aware of in the course of a Title IX process that do not trigger any mandatory reporting anywhere else in our policies. Mandatory reporting laws generally only apply to minors. So what about a senior at the high school who's 18 years old and the victim of a sex crime, but was not directly witnessed by a staff member? That would not trigger any mandatory reporting. What about non-contact harassment, some stalking? These types of things may not fall under mandatory reporting, but do fall under Title IX and still could be considered crimes. Obviously, there is a hole here. There's a gap in the policy. We are not duplicating those policies by requiring staff to report to law enforcement if they become knowledgeable of criminal sexual harassment, stalking, domestic violence, dating violence, sexual assault, fondling, incest, statutory rape, sodomy, or any other items addressed in our current Title IX policy. And if you can counter everything that I've said and prove that it's covered elsewhere in policy or law, then what would be the problem with doubling down and putting it in this policy as well to avoid confusion, to ensure the safety and protection of our students? Again, Title IX processes are not intended to replace legal proceedings, and an attitude that supports that notion is dangerous to the students that we are here to protect. The safety of our students and staff is our #1 priority. If we do not use this opportunity to expressly require sex crimes to be reported directly to law enforcement, then what are we even doing here? How are we protecting our students? If we have to wait for the complaint to be run up the flagpole and give one central office administrator discretion to decide what gets passed on to law enforcement, then the result could be a flat-out failure to report or significant delays of days or weeks, as we have seen on other issues. What can happen in those days or weeks? What additional abuse could occur? We are put here to protect the students. Let's do the right thing, protect those students with an abundance of caution by ensuring law enforcement is part of any potential criminal investigation.
Thank you. Any additional discussion? Any questions for Mr. Scott regarding the verbiage that was in the Brighton policy? How it's, I unfortunately did not print that, that email, so I don't have the Brighton policy in front of me, but you mentioned that there's a paragraph there that addresses this, but it's not quite the same as what you had proposed.
No, it's
correct?
not quite the same, but it does address it. I have it if you'd like to review it or if you want to pass it around. Says in appropriate circumstances, a district employee will notify law enforcement or child protective services consistent with policy, and it references some of their policies. So again, you know, we're being told to put that language in our policy is duplicative, but Thune puts it in the Brighton policy. And then it goes on, the district will attempt to comply with all law enforcement requests for cooperation with related law enforcement activity. In some circumstances, compliance with law enforcement requests may require the district to briefly suspend or delay its investigation. If an investigation is delayed, the district will notify parents in writing of the delay and the reason for the delay. There we have parental notification. If the district's investigation is suspended or delayed, supportive measures will continue during the suspension or delay. If law enforcement agency does not notify the district within 10 days, the district's investigation may resume. The district will notify law enforcement agency that the district intends to promptly resume its investigation.
President Coleman, I would like to ask either Mr. Hughes or Mrs. Gregory to chime in on this, since they're, you know, they're closer to this and they can give us some context.
Sure, that would be great, Mr. Hughes.
Yeah, first of all, let me say, you know, getting stuff last minute again after this has been on the table for some time, you know, doesn't help anybody, but it is what it
What's
is.
last minute?
This morning.
What?
You
My
sent us-
Sent
recommendations,
policy this morning.
my
but anyway.
recommendations have not
Okay,
changed.
never mind.
And I sent the Brighton policy. I'm pretty sure this is the second or third time I've sent it.
Can I talk or no?
Please.
Okay. So now that I have the floor, a couple things. One, certainly within our policy, the reality is that we are aware of a sexual situation, which is a Title IX, that moves up the chain from the building to the compliance officer, which would be Mrs. Gregory or Mrs. Rosenthal, and certainly in any investigation. I think the language that was read recently, just a few minutes ago, I think the first sentence says, when appropriate, right? When appropriate, the law enforcement shall be notified. Well, first thing has to do is investigation has to occur to ensure that something needs to be reported. Sometimes, you know, we'd love to say, you know, anything and everything that's reported to us is true. It's not always found to be the case in an investigation. So We did talk with our administrative team. I'm going to have Kate talk about the process for how both parties are notified, because under the law, under Title IX, both parties do have to be notified. That is the process. So that's already inherent in the process. So Kate's going to talk about that in a second. We also talked with all of our administrators about, do we think it's prudent that we require our teachers to report to law enforcement when we train our teachers to come to us as administrators when there is a concern? And we feel like anything, such as mandatory reporters, we work with our teachers, we sit by them, and we make that phone call, we do the reporting, and we always do that together. We would never ask our teachers to do that on their own without some support, because that can be pretty anxious, and that can be anxiety-driven. So we do that. Sometimes they meet with a counselor, and they do it with a counselor, and that's okay too, or a social worker, and that's okay too, but they have a support mechanism there as they're reporting. So mandatory reporters, that's how we train them. That's why they come to administration and talk about what they have heard, witnessed, seen, and then do that mandatory report. So it's all built into that policy. That's why we reference that policy, but we certainly don't think that this policy should say the teacher is responsible for reporting. It should not be that way. And that we do agree 100% law enforcement should be notified if indeed the investigation finds that there's merit to the investigation and law enforcement are called. So, Kate, would you talk to the board about the process under Title IX and how we deal with the complainant and the defendant?
Yeah, and first I want to say there are certain things that would come to us that we wouldn't, if it meets the level of threshold that is pretty significant and severe. We have all been trained that we don't necessarily begin those interviews, because if we're talking a sexual assault type situation, that student needs to go through a care interview through La Casa. We've been trained that I don't question a student to then have a law enforcement officer question a student, and we put them through that trauma multiple times. So there is definitely certain things that, yes, we go back to and look and see if there's any validation to, do we start this investigation? And there's other things that go directly to a law enforcement and directly to a care interview through La Casa. Now, that being said, once we have a complaint regarding Title IX, I reach out to both parents, the complainant and the respondent parents, within 2 days of that complaint. Again, depending on where it is and if we're able to determine any sort of truth or question that we have to follow up. A lot of times it happens within the first couple hours. From there, after I speak with both sets of parents, I send a formal letter with the policy home that explains our process to everything. We've then assigned an investigator who will go through and work with the complainant and the respondent. Both parents are invited to those interviews with those children so that they have their adult representative. If we have to investigate and interview any other additional children, those parents are contacted and they are invited in on that interview as well. So the whole time, parents are being alerted to this process. Once we are done, that investigator will create a report. That report gets sent again to both parents, complainant and respondent, through email and mailed home. So they both get those reports. They have 10 days to respond, and that response will then go to the decision maker, who also gets that report. So they get 10 days to come back and give any other additional information to the decision maker, and then from there, the decision maker will issue a final statement that again is in written form and goes back to both parents. So that's the communication with the parents. There are certain things that when you chat with parents that they want law enforcement involved, and there's occasionally times where they say, no, I do not want law enforcement involved. Now, what we have the privilege of is we have 2 SROs, and typically these sexual harassment type cases happen at the secondary level. Typically, our SROs are in those 2 buildings and they're able to answer our questions as we go forward and we work our way down this path. But yes, there's definitely things that before we even touch it, we have to alert the police because we're not getting in the middle of an investigation. And truly, our deputies aren't getting in the middle of that either. They're scheduling that care interview with La Casa because we have to be careful for our potential victim.
So what I hear you saying is this procedure based on like an administrative procedure that you have for the district? Is this based on what the law requires you to do in these steps? What?
This is legal through Title IX, but also to keep everything fresh, we do meet as a county, I would say 3 times a year. So we meet at the La Casa building, and our compliance officers of all the districts, the sheriff's office, the prosecuting attorneys, the La Casa staff, so that we're in communication, because it's if they're doing a legal investigation outside while we're trying to do an internal investigation here, we've got to be able to work together, right? And that legal investigation, if they tell us to stand down, is going to take precedent so that they can do what they have to do before we do what we have to do.
So I hear you saying then that administration and who in the Title IX person has different training than what teachers and staff have training when it
Correct.
comes to what needs to happen, what steps need to be followed, what you can do and can't do.
Correct. Staff get the training that essentially reviews what sexual harassment is.
Yes.
And that they can't turn a blind eye.
Right.
And that they have to report it. From there, it goes to administration. Administration turns it over to the central office and says, hey, I think this is what we're dealing with here.
Okay, thank you.
Ms. Gregory, thank you for that overview. And basically what you describe is exactly what I'm asking for. I'm just asking for it to be put in writing so that there's no question. You mentioned you're notifying parents. That's fantastic. Let's put it in writing because we need to be assured that whoever in this position is following the same processes, policies, and procedures.
Doesn't 2266, doesn't it have it in policy that we've got to alert parents within 2 days?
Well, like I said, it's poorly written and hard to read, but there is something about involving
Can you
one of
give
the
us
parents
the page
on the
number?
initial, that's only on the initial report or the initial complaint. There's nothing about follow-up on subsequent. It's the middle of page 6. It says, when a report of sexual harassment is made, the Title IX coordinator shall promptly, of the Title IX coordinator's receipt of the report of sexual harassment, contact the complainant. So I think it's only the complainant, and it's only upon the receipt, and it's worded, the wording needs fixed to read correctly. But, so part of it's in there. But what I'm asking for is that everyone involved, their parents are made aware, not just of the initial complaint, but the progress throughout the process, and especially of any consequences put down on their child. So if you're saying my child needs to see the counselor 5th period every day for the rest of the year, I want to know about it. I should know about it. I deserve to know about it.
So that is part of the,
needs to be-
sorry.
Go ahead.
That's part of the conversation when I call both parents, is we
Great.
put supportive measures in for both students.
Great.
To
Let's
make
put
sure
it in
that they are
writing.
both comfortable through the process, because we're not saying anybody's innocent, we're not saying anybody's guilty. We are asking the parents to talk with their children. Do they need anything while we go through this process to ensure that they both feel comfortable in school during the time?
That's great. Let's put it in policy.
So in paragraph 6, it does say complainant only. So I think that might be a simple change that I'm hearing you say that did you find it? So on page 6, it's the paragraph that starts, when a report of sexual harassment is made, the 6th paragraph down. What I hear you saying is that, sorry, 8th paragraph. On page 6. I know the pages aren't numbered, I know.
It's the paragraph directly
know.
above them.
Yeah.
It's right above emergency removal.
Right in the middle.
I know, mine aren't either. That's okay.
It's hard to read anyway because it's it's not configured correctly, and that's not in the draft that's in our actual policy right now. So there was a mistake made when this was revised last. But, so I agree with most of what you're saying. Again, I think we just need to put it in policy so there's no question, and we need to have consistency from Title IX. A big thing with Title IX is consistency, that you're treating every case the same. And I can tell you, as a parent, before I was on the board, I spoke at that podium about an incident where police should have been notified immediately, and there was a 3-day delay. In that 3-day time, the teachers' union was brought in, the teacher who was under investigation was notified of the allegations against him. Everything was done internally before law enforcement was notified. And Mr. Hughes and I sat down with the undersheriff and had a discussion about how this should not happen. We have to have policies that protect our students from that sort of thing. And so it's great to have somebody in place today who's going to make a commitment to keep parents involved, but if it's not part of our policy, if it's not part of our procedures, it means nothing tomorrow.
I've got a question, but I'll wait until Kate and Dave catch up. So to address Mr. Scott's concern about let's put it in writing, the procedure that you walked us through is in writing somewhere.
Now I'm wondering if it's the administrative guideline
Okay.
that it has the 2 days. Within 2 days, we talk with both complainant and respondent.
Sure.
I know I read it today.
Yeah.
Because I went back to
So
double
so
check.
it's not, so that's the difference between procedure and policy, right?
So do you think then adding respondent to this paragraph makes sense if we were to add,
And fix the wording
And
of the
fix the-
paragraph, yeah.
make it more easier to read? I mean, do you, and if you want to look at it later, maybe let us know, but if that's, I mean, I agree, it should say both.
It's what we do.
Right.
So-
It should align with what we do and what's required.
Calendar says respondent at the last sentence. It finally says respondent at the last sentence of that paragraph.
Oh,
Yeah, it does.
So really, respondent should be through that paragraph.
It should. Okay.
But that section only applies to the initial report. So again, as Mrs. Gregory described, she's keeping parents informed at every step of the way. So it needs to be made clear in policy that that's what we're doing.
Yeah, I guess where I struggle with that notion, though, is muddying the waters between policy and procedure. And I don't necessarily support the idea of putting every little step that administration follows, not just for this, but for anything, spelling it all out step by step in a policy versus having it in an administrative guideline or another administrative procedure document.
I mean, it could, if you don't like the language I have suggested, it could be as easy as going through it, and every time it refers to notifying a student, you say, and/or their parents or guardians. I mean, that would solve it too.
I'm not sure where to go with this one. It sounds like we need to, at a minimum, address the paragraph that exists to see if we can reword it, include respondent throughout that paragraph. But there may be obviously other places to include respondent and/or parent and guardian for further communication.
I'm happy to sit down with Ms. Gregory over the next few weeks and see if we can come to some meeting of the minds here, rather than just, striking out all my proposed language. Find a way we can work those ideas into what it sounds like maybe we already do.
Yes.
And Mrs. Coleman, to your point too, and this is a minor little issue, but I do have a little bit of worry about what is considered a guidance document versus a policy, and are we treating the same? Are we treating each as the same, as equals? Because guidance is one thing, a policy is more enforceable. So.
I think to answer that, Glenn, the guidance is to go along with the policy to ensure that the policy is being enacted on as it should for our regulations, so that everybody is doing it the same way. So for instance, in this policy, if you go to the end where it talks about investigation of a formal complaint of sexual harassment. You'll read through that and you'll say, the parties, right? The parties. Doesn't say the defendant, doesn't say the perpetrator or the one that was perpetrated against. It says the parties, right? So we take that language, because this is federal law, right? This is how they write it under the federal law. So we make sure that our guidance document says, okay, what does it mean by parties? It's both parties, right? Now, what Mr. Scott is asking us to do is, okay, can you make sure parents are in there? And okay, we can look at that. That's reasonable to say, where it says students, we could put it in parentheses, and their parents. That's reasonable. We can do that. That's pretty simple, right? At the same time, we have to understand that any child in our district, we have always taken the stance, regardless of age. If they're enrolled in Hartland schools, I don't care if they're 18 and they're a senior, we're contacting the parents, right? Like, we have always followed that guideline, that unless they're emancipated and they have emancipation documents, then we are always contacting the parents regardless of age.
Yeah, it was just my concern over the definition of guideline or guidance. So that's not to be interpreted as a suggestion, it's to be interpreted as a supplement to the policy.
Yep.
Okay.
Again, to make sure we're all doing it the same way.
It's kind of the how. The policy is the what, and the guideline is the how. Yeah.
So I guess what I'm hearing is that if Mrs. Gregory can work with Mr. Scott and Mr. Hughes to, I guess, make sure we're including the language that we just talked about, and then to get the board something in advance of the next meeting so that we have time to review it, and Mr. Scott, will that satisfy what you're looking to do?
Yeah, absolutely, because
In addition to taking out the other language that you addressed at the top of the discussion, right? Taking out the sexual.
Yes.
Yep.
Yeah, the gender identity and sexual orientation language, correct?
Yeah, because the administrative's current recommendation of my addition on parental notification is crossing it all out with us saying it's not necessary.
That's the line.
But Thrun has said in their letter, parental notification is fine. So there's nothing from the law firm to say we can't notify parents. I think we're all in agreement that we should be notifying parents. We may be doing it already. As a board, our only thing we have control over is policy. So it's our job to make sure that the policy is we're notifying parents. Yeah.
Okay. We're good with 2266. We have an action plan in
Yep.
place for follow-up.
Sorry, I'd like to just add a couple things
Sure.
on 2266. So page 7, so just after the section we were talking about, it's titled Timeline. In the Neola packet, there is an option, and at the end of the the second paragraph that starts off saying, if the Title IX coordinator offers informal resolution process, at the very end, there's an option that says the title coordinator will provide the parties with reasonable updates on the status of the grievance process, which I think I heard us say we do that already. So I think kind of in the spirit of consistency, I would like to see that added as well. And again, that was a Neola option that we reviewed
Right,
back
and
in
I
November.
think actually I have a note in here from the last policy
Okay.
committee meeting, and I think you brought that up then. Neola option to provide status updates on grievances.
Okay.
Is what I had noted.
So just kind of to keep that train going on that one.
So if that's something that Mr. Scott or Mrs. Gregory, you can make note of to capture that when you meet. Thank you.
Then also, kind of the general comment, which maybe applies for lots of our policies, maybe as a future discussion. I think the whole preponderance of evidence versus clear and convincing, I think I would like to understand more of a legal, or get more of a legal opinion on the sort of the pros and cons of both of those standards. And I know that's something I'm not going to try to tackle with this policy, but I think because it kind of lives in a lot of our different policies. But I would like some, I guess, better explanation or additional explanation on sort of the pros and cons of both of those.
Greg, I know that in the past you'd asked for that, and I believe we did get a,
I believe
we
we did
had
too.
Thrun do a write-up to the board on the difference between the two. So I'll look for that, pull it out as an attorney-client privilege and re-forward that to you, but I'm pretty positive that we
Okay.
got that already.
All right, and then page, I think it's 12. Get that here. Scroll through here on the appeals. I didn't get to it here, sorry. So, let's see. It says, under appeal, it's under letter C. Then the next paragraph says, the complainant may not challenge the ultimate disciplinary sanction consequence that is imposed. Now, that's an option that Neola offers, which we selected it, so I'd just like to understand why we chose that option.
Do you want to go, Kate?
Sure. I would say we chose that option because by the time we're going through a formal process and we've done how many different investigations, we've had an investigator create a report, we have a decision maker who is a separate entity looking through and reviewing all the documentation. We have multiple adults at that point in time who have gone through this process, and we are comfortable with where our decision has fallen.
So is that to say they can't appeal the decision?
Well, they can go through the appeal process in the decision, because after the decision maker makes his determination, they can appeal and put that in writing and go through the appeal process, yes. But once the appeal process has been completed, the final determination is the final determination.
So they can't appeal twice?
Correct.
I think we should clarify that, because that certainly makes
Yeah,
it look,
it wasn't clear to me, so it felt like we were saying you can't appeal, but I guess under those,
Yeah, everybody gets an opportunity to appeal. But the final appeal, once that appeal has been made, if that decision is upheld or whatever the decision is, that is the final decision.
So maybe that sentence needs to say sanction consequence that is imposed after appeal?
Or wording that I had captured from when we discussed this last time was the decision of the appeal is what's final. Of any appeal is what's final, not necessarily the decision. I mean,
Right.
obviously, that then becomes the ultimate disciplinary sanction or consequence. If there is an appeal and there's a decision made after the appeal, then that would be the final one. I had that written in as a clarifier.
but then they still have the option to make a OCR complaint, right?
Yeah, they can always do
Yeah,
that.
beyond that,
But-
yes, because then that's somebody else making the decision, right?
That sentence seems to be out of order.
yeah, it just,
Or it needs to be at the bottom.
Yeah.
so maybe, Ms. Gregory and Mr. Scott, if you,
Yeah.
when you get together, if you
Yeah.
can take a look at where that belongs or how to better phrase that so it's more clear.
So if you read farther down too, it does say both parties shall have the reasonable equal opportunity to submit a written statement in support of or challenge of the outcome. They have both parties have a right to appeal. All appeals, Title IX coordinator will notify the other party in writing when an appeal has been filed. And the example we used last time we talked about this was new evidence coming up. So what would happen is you have a right to say, hey, I've got this new evidence. Well, then that appeal is automatically kicked back to the decision maker. The decision maker will consider that new information and then make a final decision that becomes the final decision. So your appeal has been heard through the new information by the decision maker, but if the decision maker chooses not to do anything different, then it is something that stands, and that ends the appeal. And that's the law, that's Title IX, that's how it is written and expected to be enacted.
Okay, sorry, one more that, I guess on the, under record keeping, it is the second to last page. Just above where it says outside appointments, dual appointments, and delegations. It says the district will make its training materials publicly available on its website. So in the Neola packet, and I think kind of in the spirit of accessibility, there was an option that we could choose that said, if a person is unable to access the district's website, the Title IX coordinator will make the training materials available upon request for inspection by members of the public. So I think that might be something we would also want to consider. Again, I think probably most people can go to the website, but if there are folks that can't, it would be something I would recommend that we add.
To be able to have the printed copies? Is that what you're
Yeah.
asking?
Yeah.
That's no problem.
And again, it was something that Neola had in there.
Okay. Anything further with 2266? I think between Mrs. Gregory and Mr. Scott, you guys captured those last few comments, potential things to incorporate. So I think, okay. Moving on then to the next, which is 5517.01, bullying and other aggressive behavior towards students. This is a revision. Again, this one came to us originally from Neola. The policy was revised to include the definitions and additional components included in the latest version of the Michigan State Board of Education's model anti-bullying policy. These suggested revisions should be considered for adoption, is what Neola had to say. And again, this came, Mr. Scott, we postponed this one, and Mr. Scott sent us some proposed verbiage to include and adjust in the existing policy. I'll hand it off to you.
Sure. And so my concerns here mirror a lot of what we already talked about in Title IX. As you can see in the administrator's recommendation, they pretty much just crossed out everything I said we don't need to say that. I'm going to respectfully disagree. My recommendation is to make sure that parents of both parties are notified, and again, given the opportunity to participate and understand the resolution process. My point is not a quick notification, as seems to be what is in the policy. It's the inclusion of parents throughout. This is best for everyone, the same as Title IX. I'm especially interested in making sure parents know about any proposed interventions mentioned, such as counseling or restorative measures. Am I crazy to think that parents should be notified and given consent if their student is asked to participate in a restorative conference or asked to complete counseling? A parent doesn't need to be notified about or consent to community service, restoration, restitution, restoration of emotional losses, whatever that means. Frankly, I believe what is in this policy is unconstitutional. Michigan expressly recognizes every parent's right to determine and direct the care and the teaching of the education of their children. It's posted in very tiny print behind President Coleman. By not including the parents in the process, we are without a doubt promising to violate parental rights here in Hartland. We can talk more about that, but similar to Title IX. As far as law enforcement notification goes, I see the administrators did make a small concession here, offering to notify law enforcement, but took away my recommendations for detailing how the notification occurs, how it's documented, et cetera. I hope that maybe this is another one that Mrs. Gregory and I can work with on making sure what is actually being done is put into policy, so that we as a board are not abdicating our duties.
I guess just with the last one, if Mr. Hughes or Mrs. Gregory could talk about what this looks like with the administrative team, and if there's administrative procedure that you're following for this as well.
Yeah, again, I can't speak to any time in which we're not dealing with a student that is claiming that they're being bullied and that we're not responding to both parents and filling both parents in. So maybe that someone knows of something I don't know, but the reality is, again, our standard procedure is always notification of both parents because we're dealing with their students, so that parents would know how we're dealing with the issue. If counseling is being required, for instance, the only time we absolutely require counseling is certain situations where there's mental health concerns, and we, certainly the parents are involved in that process, right? So if Mr. Scott, again, when he meets with Kate, wants to go through this policy and where it says the student will be, and say, and the parent or guardian, I think that's fair to make sure that that's what's done. But I know that it is done on every case that it's expected to be done on. So now keep in mind, there is always, even when this happens, sometimes there's a confusion by parents on what bullying really is, right? Someone was mean to my child today. It's not progressive, it's not consistent, that's not bullying, that's a mean behavior. And normally the student is reprimanded and the parent is informed that their child was being mean today. Maybe in that case, I didn't notify the other parent, I don't know, maybe. But, sometimes kids are mean to each other, or sometimes kids get involved in they're teasing each other, right? And you deal with that, and you might have to contact both parents. So it's not always bullying, but we have to determine the depth of the complaint, and is it pervasive? Is it occurring over and over? And does someone now have the upper hand, right? Someone becomes, the person that controls the situation, right? So I certainly would welcome Mr. Scott to, when you come in to meet with Ms. Gregory, to go through this policy and talk about where you might add parent and guardian will be notified along with this. I think that's fair.
I mean, under notification, the second paragraph, it does state parents or legal guardians will be promptly notified. And, I'm not sure, and I guess maybe Mrs. Gregory or Mr. Hughes can talk about the 24 hours that you're recommending. I'm not sure that's always I'm not sure putting a time on when they have to be notified makes sense. There may be circumstances in which that may not be possible or safe or anything like that. I think that promptly, covers what you're trying to accomplish. This does state that parents will be notified.
Correct. It's on the middle of the first page. My concern comes to the consequences, making sure parents are notified of the consequences. You can call home and say, hey, Johnny was bullying Susie today. Okay. But now if the consequence to Johnny, again, is mandatory counseling, that needs to be conveyed to the parent. It has to be. So that is my point. The current policy allows for that step to be missed.
Okay, so I need to understand so that we're not in violation of FERPA. You're talking about the student who might have been doing the bullying. Absolutely, the parent should be involved in the consequences for that student. The student that was bullied, we are not at liberty to share. So you're not saying that,
I'm talking about a parent and their child. That anything that happens with their child, they should be notified of. I'm not saying that they need to know the consequences of the other party. I'm saying if there's consequences to a student, whether he's the bully or the victim, or going to be in a restorative justice circle or whatever, the parents need to be in on that.
And again, I think the notification section really takes care of a lot of this, but, certainly if you and Kate want to talk about it, go ahead and talk about it.
Well, it doesn't talk about the consequences portion. That's what I'm talking about. Again, yes, that's good to notify the parents that there's a problem, but then we need to keep them in the loop with the solution.
Agreed, and thank you for asking for that clarification, Mr. Hughes, because I was going down the same path, concerned that, Susie's parents don't need to know how Bobby's parent or
No.
Bobby was disciplined. It's only for their own child. Yeah.
Correct.
So as long as that's clearly spelled out.
Yeah, and we use the word discipline, but a lot of these are these, non-consequential, whatever you want to, sanctions or whatever they're called. And it can be, there are schools that cross lines with counseling and turn counseling into therapy and these sorts of things. And we need to have protections in place for our students. So those lines don't get crossed so the parents are kept in the loop.
And again, in that policy, just so that it's clear, the administration does agree that if the investigation reveals that the bullying crosses the line to become a criminal activity, then yes, we're going to report that to the officer, and the officer's going to take it from there. And you can imagine probably some bullying situations could definitely be criminal in nature. So we agree that should be in there.
Yep, agreed. So that was referenced in the administrative recommendation for that section. And it's in that next paragraph on page 2, right above reporting. All right, so follow up here, kind of in tandem with the last one. If you, Mrs. Gregory, and you, Mr. Scott, will connect and make any additional tweaks there so we have something final to present to the board at our next meeting. Is there any further discussion?
I just saw a typo, so I'll just point it out in case it's not been caught yet. So on the very first page, the language that's being added, or at any time or place where a child's imminent safety, it looks like we got an extra M in there, so point that one out to correct, minor, obviously. I did also want to ask on page 4, make sure I get the right page here. It's a section that that's been removed by Neola. And let's see. It says, school employees will also be held accountable for bullying or harassing behavior that is directed towards school employees, volunteers, parents, or students in accordance with law and local collective bargaining agreements. Again, page 4, first paragraph, last sentence. So are we striking that out because
Your
we're?
page numbers might be different, or the page breaks might be different.
Well, it's the one that we were handed, so I'm
Okay, can
hoping
you-
it's the same.
Yeah, can you give me like a header or
I
something?
didn't have one, but let me go
It
back.
starts with the best discipline for aggressive behaviors is
Yes, thank
designed to, but it's struck out.
Oh, okay.
It's what we struck out, because basically it infers that we're not holding employees to the same bullying, harassing behavior. Is that because we're covering that in another policy? Or why would we strike that out?
Since it says end of option, I'm wondering if we selected a different option in its place.
Yeah, and that's my question, I guess, is why is that gone? Or where did it move? Maybe that's something
My
you and
guess at the
Mr.
top of
Scott
my
can
head
look
is that it's
into.
in with the staff section, and this is the student section.
Yeah.
It's my initial.
Okay.
I-
Perhaps that's the
'cause
case,
it's-
but if
it's
we can
the
check that.
5,000.
This is sounding
Wasn't sure
vaguely
if it was
familiar.
part of 1422, 3122, 4120.
Yeah,
that
I'm
whole
almost certain
packet we looked
it's in
at
one of the
before,
other
but
ones, because obviously we wouldn't condone our staff in that behavior
I
either.
assumed that to be true, but
Right.
since it was struck through, just thought I would double check that. And then I think the other one was just kind of we selected the option of restorative practices. I'm just wondering if we can talk, that's on page 3, sorry. The district will utilize restorative practices to emphasize repairing the harm to the victim and school community and the correction of bullying behavior, which may include victim, offender conferences, and it goes on.
I'm sorry,
I'm just
Is this the
trying to
section
understand why
that's-
we selected that.
Okay, so you're looking, it's the green section on page 3?
Nope,
No?
it's not. It's the bottom X that was checked, right above where it
My
says
page
end of
3
option,
My page
eighth.
3 is different,
Okay.
yeah. Sorry.
So then it's the last section before procedure. Or I'm sorry, I got my
It's on
pages
page
mixed.
4
It's
for me.
not-
Yeah.
It is.
Okay, I found it. The district will utilize restorative practice that emphasize repairing the harm.
Could Mr. Hughes or Mrs. Gregory maybe chime in on?
We struck that or we added it?
We selected that.
Selected it.
So we do use restorative practices, we offer it, and keep in mind what restorative practice is. Restorative practice is, you talk with both parties, And a lot of times, parents want to do this by themselves. Parents want us to give Billy's mom wants Timmy's phone number so that they can do it themselves. And we say, oh, no, we don't do that. But if you would like to get together and we can talk this out, and Billy can talk to Timmy about why, what he said or what he did hurt him, that's restorative practice. So you allow them to work it out. Now, you don't force it. You can't force two children and two parents to do that, but you offer it. So we always want to offer restorative practice. We always want to give you, Greg, an opportunity to tell me, Chuck, why I hurt your feelings, why this was bothering me, why I reported it, right? So we try to use that to help get that situation, kind of like the old, when we were kids, the teacher or the coach would shake his hand and say, you're sorry. Remember those days? Yeah, that's really,
get
but
that.
this is a little bit more in depth.
I guess the nuance, and maybe I appreciate the context, but in this case, it says they're initiated by the victim. So that's me asking you to tell me you're sorry, not
No, it's,
saying I should apologize to you. So a
it's
little
me,
bit
the administrator, disciplining the other, or talking to the victim. Would you like, and the parents, would you like to engage in restorative practice to try to figure this out so that both children can move on and somehow get along? And so the victim has that right, that you're the first one we're going to ask. And if you don't want to, then we don't pursue it. If you say, and the parent says, absolutely, I would love to sit down with that other, child and my child to get with them. And usually what we do is say, parents, can your children engage in this? Not the parents in the room, because that doesn't help. It's the two children in the room with a professional, a counselor, social worker, school administrator, to let them work it out. That's restorative practice. But you have to agree to it as a victim.
So would it be okay then if we got rid of A? 'Cause
What does A
I don't
say?
think
I don't
it
have that
It just says are initiated by, because it sounds like they have to ask for it. Whereas what I'm hearing is we would recommend, we would initiate it to
We
the
could-
victim and then they would approve it. So I
Would-
feel like A doesn't necessarily belong in what
I
you
think it
described.
belongs there, but maybe it just needs to say, the district will offer the victim an opportunity to engage in restorative practices. Maybe that's a better way of saying it.
And I have B highlighted to discuss at our meeting because it says approval by the victim's parents, not the bully's parents.
Yeah, you're
Yeah,
stealing my thunder. but-
Oh,
Can't-
sorry.
You can't do it. I mean, the reality is you can't engage in restorative practice without both parties saying yes and both parents saying yes. So the victim has the right to say, I'd like to. So maybe we just need to clarify in that sentence that the victim has the right to, engage or ask for restorative practice, the victim and the parents. or
I would say a
guardians.
lot of times this is used when there's misinformation, right? Or there's other students who get in the middle of a situation that is involving two students that the story gets the game of telephone, right? And so sometimes it's nice to bring two kids back together to say, okay, what were we really talking about here? And it's a complete misunderstanding. But yes, they both have to be willing to partake in order to do this.
Yeah,
But yes, I see what you're saying. You want both parents, not just the victim's parents, you want the other parent listed as well.
and to sign off on the consequences, because again, this isn't, shake hands and say you're sorry. This is, participate in community service. What is this, 20 hours of roadside labor? We gotta, this is way different than shake hands and say you're sorry.
I think what A is really saying is that the victim is the one who asked first. They have to be sure they're there. So initiated probably isn't the best word.
Yeah.
How do you word it to say that the victim has to agree first before we even consider asking the bully to do it?
Okay.
So that's noted as an additional follow-up or part of that follow-up. Anything else, Mr. Keller?
No, thank you.
Okay. All right. Everybody else good with 551701? Okay. All right. Moving on. Other notes here. All right. The next one on the list is 2210, curriculum development approved courses. This was a revision. As you may recall, this policy was postponed at our November 17th regular meeting. I'm not aware of any further developments or recommendations from board members or administration regarding this policy or the recommended changes. I know some board members, Mr. Gogolewski, we just made eye contact there, were concerned with respect to the recent curriculum changes at the state level. So has there been any further development here? Is there any discussion that you want to cover tonight regarding this?
Yeah, I just had this quick casual conversation with Mr. Minsker right before we started. And after a couple of months of referring to different sources and contacting different people, those state changes, those guideline changes are truly, they're not mandates. They're not things that have to be abided by. It's something that a district could choose to implement. So with that, that kind of single-handedly handles all the questions that I had at the time. However, looking at 2210 on the first page of it, if you go down to the bottom, there's a section that says the board directs that the curriculum of this district, and then it gives A, B, C, and D. B says provides instruction in courses required by statute and State Department of Education regulations. I would like something in there to say that this does not include recommendations by the state. Something to be a little bit more meaty and a little bit more specific, stating that, no, if it's a recommendation, this is something that we can choose to implement if we want or not.
Mr. Hughes or Mr. Minsker? I don't know the ins and outs of that and to know the difference between a recommendation versus what's in the statute, what's required, what's optional. I don't know do you have any ideas on how we could implement some wording there?
Yeah, I know what he's trying to say. I mean, this says anything that's required. So anything that that MDE or the state says you require, which is all those state standards that are required in the core classes. In the situation that he was talking about, that was a recommended issue through health that districts can choose on their own if they want to do. So it's not a requirement. We can choose on our own. So I don't know how to word that. I mean, he's not wrong. I mean, you could add something like that and it wouldn't change what we do or what it's doing.
I think we could add an E and just say, all state recommendations, not mandates, must be approved by the Board of Education. I think that's
Yeah,
fair.
that works.
And that way it's brought to the board and the board says, yeah, we'd love to adopt those recommendations versus mandates.
We would do that anyway.
Yeah.
So, yeah.
There's actually some
So is that
subsequent
replacing
letters.
E, or are
No.
you talking about adding an E?
I'm just
Yeah, he's
adding
saying
an E.
Adding, but yeah,
Right.
there's
But it's L.
additional letters.
Oh,
That it goes on the
Right.
next page.
Well,
Okay.
because it
Campbell said
does,
it's L.
ironically, in E, it talks about incorporating state recommended, I guess that's performance standards, but I guess that would be a separate one.
Yeah,
Yeah, so
it'd be
maybe,
separate.
yeah, L.
instead of E, we'll make it L. Again, if that, Glenn, does that fix it for you?
Sure, just for the sake of maybe not adding into the alphabet soup list of all this, just, I was wondering if it might be a little bit more prudent just to make B like B1 or something like that, and just have that little disclaimer right in there with that current sentence, as opposed to just
So it would be-
adding more and more provisions that,
Any state recommendations must be approved by the Board of Education?
Okay.
Is that what you're talking?
yeah.
All right, so I'll work with Renee on how to finesse that in there. That work?
Is that okay?
I think that's fair.
Yeah.
Is that true of what we've done before? If it is a recommendation and not a requirement, has that come to the board before for approval? Can you think of an instance when it has?
I can't
Well,
think of one.
sex education is the one that keeps popping in my head because that has to come to the board.
Right.
That's
Yeah.
that's a law
But
that has to come
besides
to.
that, Is there anything you can think of that?
There'd be some things, I guess, that we would do because we thought it was right for kids to do, but it wouldn't necessarily come here.
Okay, thank you.
But I can't think of anything off the top of my head.
Most things are mandatory, like the standards and benchmarks, if you go to the MDE website under curriculum, standards and benchmarks, those are requirements. And then, of course, the graduation requirements under the Michigan Merit Curriculum and the standards and benchmarks that are associated with those classes, they are all mandated, like we don't have a choice.
We may have electives, some electives that are not part of the core state standards that are really just up to districts to create the curriculum and to do. They're not required by the state. They don't have any recommendations. We just got to do it.
And those ones
So,
come to the board in the,
They come to the
usually in
board
the high
anyway,
school
right.
curriculum guide is really where those take place, so.
Right.
So in the paragraph where it talks about superintendent may conduct such innovative programs as are deemed to be necessary, could you give an example of what you would consider to be an innovative
STEM
program?
might be an innovative program, like we're moving forward with STEM, and STEM is following the state standards and benchmarks for, science, technology, engineering, and mathematics. So, but the board would have, again, known that we were moving forward with STEM because that was part of the bond project to build the STEM labs, to add STEM, across the district. So the board would have been a part of that solution or that process anyway.
The reason I ask is, which I think you're kind of confirming what I would have suspected, but in Neola, it says, after that sentence, the superintendent shall report such innovative program to the board along with its objectives, evaluation criteria, and costs, and then it would say add before it is initiated. That was an option that Neola offered, so again, you're just adding before it's initiated, which I think you're saying we would do that anyways, so consider adding that.
Okay. I didn't argue with you.
Okay, anything further on 2210?
One item. On the second page, close to the middle, it says, "The superintendent shall make progress reports to the board periodically." And I was looking for something to be a little less vague than periodically, like maybe at a minimum annually.
Isn't that covered under the superintendent evaluation, that when we do that, really 4 times a year, right? And you're talking specifically for curriculum.
Yeah, I'm talking specifically for the line item in page 2 here. So,
I mean, we get it at least biannually, right? We talk about curriculum at the 6-month and 12-month evaluation for the superintendent.
Yeah, and
right now, maybe we do, but just to codify it and make it a little bit more distinct, I'd recommend to say at a minimum annually.
yeah, it's being done anyway in the evaluation process, so I don't care
But
periodically.
I guess my contention there would be the evaluation process is closed door. I read that as more of a public report out to the board about curriculum updates.
And then that would be annually, probably in the high school curriculum guide that comes to you in regards to, that's happening annually anyway, so, and that's public meeting. And that's really where the only changes usually occur.
Okay.
And unless we have another change in curriculum, like the innovative programs, it's going to come to the board anyway, so that might be more than annually, depending on what's going on.
Yeah.
Well, and we do
But-
have curriculum reports as well, where the coaches come in. So I feel like it's done quite periodically.
And the happenings, the building happenings, they're talking about curriculum, what they're doing in their buildings, so.
Yeah, so if we were to add, instead of periodically, say annually at minimum.
Yeah.
Wonderful, yeah.
Beautiful.
Just as a reminder too, you guys have access to all the curriculum. I have a shared document that you guys got last year, I think last spring, maybe.
Could be.
So that's there, and we update that whenever we make any kind of changes, so.
And we get the newsletters that you send out, that your coaches send out to everybody as well.
Yep. Okay. I think we can move on from 2210. The next one up, this is two policies essentially together. 0144.2, and then a new policy proposed, which would potentially be 0144.5. Mrs. Shaw brought the existing policy, which is point 2, board member ethics. She brought this forward to suggest some modifications in line with what some neighboring school districts have put in place. And so we'll discuss all those. And then obviously I've mentioned the other policy. We'll cover them one at a time. Let's discuss just one at a time. But I just wanted you to have both of them in mind because they are kind of closely related, obviously. The second one that she is proposing as a new policy is violation of board member ethics. So it's kind of a sister policy to this one. And let's focus, if we can, just keep our discussion on the policy itself, not details or specifics of any recent events, or we can refer to some examples perhaps, but let's not go down any rabbit holes. Let's keep the policy or keep the discussion strictly to the policy verbiage itself, and keep the discussion focused if we can. So Mrs. Shaw, if you would kick off this discussion for us.
Thank you. I am bringing this policy to you for updates to add a few items which I think are necessary based on my experience serving on this board for almost 4 years, as well as what the community expects from elected officials who represent Hartland schools. The reality is that we have board members trying to operate in isolation all of the time, and this is referring to bullet point E where I've suggested updates. We are not a board of one. We are a board of 7, and one board member does not have any individual authority. This bullet reinforces this point, as well as that the superintendent is the district chief executive officer. The reality is that we have board members who want to act as superintendent or to blur the lines of delegation between the board and the superintendent, and this is referring to bullet point F that is new. The board does not make day-to-day decisions of operations of this district. We set policy. Everything else is left up to the superintendent. We are not part of the administrative team. The reality is that we have board members who want to disrupt or impede administrative structure that has been established by board policy and district procedures, and this is bullet point G. We do not perform the duties of the superintendent or district employees. And again, we are not part of the administrative team. And I am going to read the third R from the 3 R's of Hartland that we all know so well. The third R is responsibility. Students, staff, and parents take responsibility for their own actions and behaviors. We expect that everyone extends that responsibility to working with individuals, groups, community members, and others. This collective responsibility supports Hartland School's effort towards cultivating a positive culture where we learn and grow together. Engaging in rational discussions that promote community is important to the development of each person. Being responsible means demonstrating accountability for our own actions and representing our school district in a positive manner without exception. Our students are watching and listening to us. What we say and what we do is a reflection of Hartland Schools. This responsibility, as outlined in the third R, also falls on board members. It falls on each and every one of us. Thank you.
Okay. Thank you, Mrs. Shaw. Are there any questions or concerns regarding any of the suggested changes to the existing policy?
I just have a quick question, President Coleman. You mentioned that some of these are meant to kind of mirror or reference neighboring districts that have made similar changes. Do you know which districts those are?
This policy incorporates some things from Brighton schools and Howell schools.
Okay, thank you.
Vice President Shaw, can you expand on what you mean about working with other board members, not in isolation?
Sure. I think that when we're making demands of district staff or the superintendent for information or guiding him or making suggestions of things, a lot of times there are board members who are operating as a board of one and making demands of the superintendent. We can only direct the superintendent when the board makes the decision to direct the superintendent. It's just a reminder that we have to act together in one voice, not individual voices, not individual directives or demands. It's us acting not in isolation, we're acting as a board.
So it's not meant to say someone can't create their own policy and bring it to the table? I mean, because otherwise, in this case, we're basically, you would be asking for yourself to be penalized by the next policy because you wrote this in isolation. I'm just trying to make sure that that's not the intention, because that's the way I read it.
I'm not implementing policy in isolation.
But
The
it says
point of a
work.
policy discussion is so that we can talk about this as a board and make a decision as a board.
And then, so also in E, it talks about who's recognized as the district's chief executive officer. I think policy 1100 already notes that. So do we want to reference that policy in here?
I don't think it's necessary to reference another policy if we're just designating what the title of the superintendent is.
Because I think I mean, it's already in policy, so I'm trying to understand why we need it here too.
So if it is in policy, and what did you say it was, 1100?
It should be 1100.
We could reference that. We do that in other policies, if you would be open to that.
Yeah.
We could say, who is recognized as the district's chief executive officer
Per policy.
per policy 1100. Because we've done that in other policies as well. I'd be fine with that.
And then can you, I guess, talk a little bit more about G, because I'm still not quite understanding what that means.
And I will confirm then about if it's policy 1100. Are you sure that's the correct reference for that one? I can double check.
I think so, but
Okay.
I think it was called district org, paragraph 4.
Okay.
Says that the recognizes the CEO.
Okay, so bullet point G, to not disrupt or impede established district administrative structure. We have had recent examples with our FOIA procedure or hiring practices of district employees. We are not part of the administrative team, and we don't make administrative decisions. The administration of this district is left to the superintendent. Again, there is a clear delineation of duties when it comes to what board members' responsibilities are and what is responsibility of the superintendent. We should not be inserting ourselves in the administration team or the decision-making of administrators. I think perfect examples, what we just talked about, a couple of the policy updates, getting an explanation from our administrators about things we don't understand, things we don't have experience with, to know what the administrative structure is and the purpose and the law they have to follow. So making sure we understand our place is not to insert ourselves in administration.
And I guess,
Is that different than F? Because it, again, kind of says the same thing.
Well, to me, bullet point F is that we're focusing on creating policy. It's to focus on government and not management, which again, could be similar to inserting ourselves in the administrative team, but that is more focused on the superintendent being the one in charge of, and this bullet point G is really talking about the administrative structure. We can combine these, we can make them all part of the same one if we want to. I just want to make sure that it's clear that board members understand what our role is and what our role is not, sitting at this board table.
yeah, both of those bullets, I can see there's
Yeah.
They kind of relate to the same topic, so yes, they probably could be combined. I mean, really, they both kind of relate to trying to avoid overreach by board members and staying in our lane, I think is the general gist of probably both of those.
Yeah, staying in the lane is one thing. Now, could that mean, or could that cover the fact that there is a board member or board members who do have questions and want answers? Is that considered disrupting or impeding the established district administrative structure if we have questions? And if those questions are not answered sufficiently, again, does that constitute disrupting or impeding the established district administrative structure?
No, I mean, we ask questions of our superintendent all of the time. I mean, I think that there's a difference between asking questions and wanting to be part of the solution or how things are handled and be part of the administrative team. We should be asking questions of our superintendent. That is what we are here for and what he is there for. I don't see anything listed here that says asking the superintendent a question would be a ethics violation.
No, I don't see it listed here either, but I want to know about interpretation. Because sometimes it seems that among the board, we have certain areas of irritation if we are asking too many questions or what have you. And I want to make sure that this is not putting some kind of blanket on the fact that we may have some questions. So, and in terms of E, not in isolation, that I think is actually covered just by us sitting in this room right now and having this type of meeting where we're not in isolation, where we're forced to talk about policies and we're forced to talk about what we feel is adequate or proper or what have you.
Yeah, I guess my concern with that was the same. Like, when you read it, it sounds like, you know, when you're working with board members to put together a policy, then you're not working in isolation. But if you don't do that and you bring a policy to the table, you're guilty of working in isolation when really you are just trying to bring something to the table for all to look at. So I think maybe your intent is different than what the wording is. So I would, you know, I can try to put together some alternative wording and make a suggestion to you, but those are my concerns, is that I just don't know that it matches what you're trying to accomplish.
Yeah, I mean, if you have some suggestions, if you want to reword it, I just think it, you know, again, bringing a policy for discussion is not establishing board policy or acting in isolation. I mean, that's the purpose of policy committee meetings, right, is for us to talk about it before we make a decision as a board. There have been many times when I would say a majority of the time that I am left out of conversations that happen across this Board of Education. I'm not copied on emails, I'm never called, I'm never included on information, and sometimes it shows up at board meetings to be added to agendas. Not acting in isolation is what I want to stress in this policy, that we are supposed to act and communicate across with all seven of us, not excluding and not in isolation. So if you have some suggestions about what you want it to say.
Yeah, so something, would it get to your point, Greg, if it was, instead of not in isolation, would it be without exclusion?
Yeah, but again, you know, not to state the obvious, but I don't know that this particular policy, not everybody even knew that this was coming. So like, would that be guilty of not adhering to E? Because I wasn't aware of it. I don't know if anybody else was aware of it.
It was in the board packet.
And I'm not saying that
Right.
I need it to be, but based on the way this is written, it could be interpreted that way.
Okay, so then I would love it if you came up with some suggestions to address that then. So let's figure out what your concern is with that, and let's find some better wording for it then. Because I get what she's trying to say, and I hear where your sticking point is. I feel like it's like semantic, Or, you know, so I,
Yeah, and I'm not trying to intentionally be that way, but I'm just pointing out that it can be
It could be
interpreted. And if you
different.
have 4 people that want to interpret it a certain way, then that's what the interpretation officially becomes. And I think we need to avoid that.
sure. All right, so let's find a way to reword that, and then hopefully that would address that. That was for E, correct?
Yes.
Okay,
So Greg, I'll look for some suggestions from you.
Sure.
awesome. All right, Mr. Scott?
Yeah, I don't disagree with most of what you said, VP Shaw. There's definitely been a blurring of boundaries in multiple directions. I think what's in front of us is a sliver of the pie and, you know, more of a symptom rather than a cause. And so I would like to, you know, take a little bit more elevated approach to this, the 30,000-foot view, and say, okay, what can we do to prevent these problems and to work better together? I know past President Glaybach and I had some discussions about like board operating procedures, and that's really what we are missing. So, you know, for instance, in here it says administrative structure. Well, we can't say what that means other than the typical line, you know, that's how we've done it, so that's how we'll do it. And what we really need is to know what that structure is. I think I've sent it to the board before. If not, I will send it again. Novi, and I don't know if this is current or not, this is from 2018, but they have like a 30-page operating procedure manual for their board, and it includes their ethics, but it also includes a slew of other things about what, you know, responsibility of the superintendent to provide information to the board. You know, what should be provided on day one? What should be provided to new folks? What should constantly be updated? That's very detailed. It talks about how board members should interact with administrators, very detailed. How board members should interact with parents, and it's very detailed. So that everybody's on the same page. And I think that is a lot of what our issue comes down to, is I'm responding to parents how I want to respond to parents, because there's nothing I've agreed to or seen that says there's a Hartland way that we've all agreed to. And that is going to ruffle some feathers, whether administrative or with other board members, as we, you know, saw with the call to public. Whereas if we had some concrete procedures in place, then we could look at it and say, hey, listen, this is our procedure. It's to, you know, first do this X, Y, Z, or whatever the case is. So I think we're in the right direction of hammering this out. But on the flip side, I don't think just changing a couple things in a policy is all of a sudden going to help the board and the administration work better together. I think we need to take a more holistic approach and try to figure this out. So again, I'll share this with the board. And I'm not saying I agree with everything in here, because there's some things I'd say, no, thank you. But the general premise that we can set standards, because right now we're just operating based on what each individual person believes is the right thing to do, or the right thing for them, or the right thing for the board. And if we don't have some common ground, then we're never going to be able to see eye to eye. And that's where the interpretation of the ethics is going to come into place, because we haven't agreed what, you know, your idea of procedure and my idea of procedure are completely different, because we haven't sat down to agree on what procedure is. So that's my 2 cents.
So, Jeff, just to clarify, or I guess just to make sure I understand, they include board ethics, probably meeting norms, all sorts of different procedural type things in this document.
Everything that we have problems with, being, you know, snuck up on us, but with this, and what happens this month, and what are scheduled, I mean, it's all laid out so that any board member, any administrator can look in here and know how to handle a situation, know what to expect, know what a meeting is going to look like. Absolutely. No, you know.
And do you know, is this treated as like an administrative guideline type thing? Is this a bylaw? Is it a policy?
They call it operating procedures. I know they have some of their bylaws in here. So like I said, they have the ethics in there and some other things that are, I believe, pulled from, but mostly, I think it's just an agreement between everybody of what the expectations are. To be honest, when I first got on the board, I sent the superintendent a list of information I wanted on the district. I got 95% of it out of this manual from Novi. And because I didn't know, I was starting from scratch. And I said, what should I be getting on day one as a board member? And I tried to look around. Our orientation policy says you get an org chart and a background check. That's it. There's no orientation.
So are you saying then that this is your project you're going to be working on? Well, that's what I hear you saying, because you think we need more.
I think this is going to involve a lot more than one person, but I think.
I mean, I don't think it's a bad idea. Maybe reach out to President Coleman and she can create an ad hoc committee, and it's something that probably will take a long time to work through. And
Yeah, what I'm seeing is kind of an iterative process, right? It's like,
Right.
we're not going to go from 0 to a 30-page document overnight.
Yeah, and I don't know, again, I don't know if this is current. I don't know if
Understood.
they got a form, if there's other things that exist. But when you hear all the challenges we have, it would be much easier to articulate what the issues are if we could look at, well, why is it a problem that, board member A talked to parent B? Well, because we've agreed in our procedures that before you respond to a parent, you're
Right.
going to, take it to the president or whatever the case is. And they literally have the responses that board members should make to parents and hear stuff like that. So again, I'm not saying I want to micromanage each one of us, but if we have that expectation, then we can articulate what our issues are right now. I think right now, we probably agree on more than we think we do, but it's hard to articulate because we just don't have the procedures to bring it all together.
Sure. So, yeah, so as part of an iterative process, I personally would still support making some changes in alignment to get us there. Use this as a stepping stone. Let's put these in place, and then we use this as one of the building blocks to create this document. I know I was looking at a couple of other districts, looking at like their board norms. So kind of, more stuff that would be included in a document like this. I was just actually making some comparisons recently. So, I think a lot of us are on the same page with that notion of creating something that's bigger, more comprehensive. But this to me is a good place to start so that we can have this to work from.
it at least
and
sets
then-
expectations.
And then add more to it and, the different types of documentation and expectations that are in something like that, then we can add to it from there. Thank you.
And I think too, like we've been saying, procedures and policy are two different things. So I think having both in place would be helpful.
Okay. Anything further regarding the proposed changes and additions to 144.2? Board ethics. Okay, so in tandem with that, Mrs. Shaw has brought forward a proposed new policy that would basically be a sister policy to this one. Go ahead.
Okay, thank you. One of the most common conversations I have with community members, parents, and voters is what can be done when board members act inappropriately or in a way that does not represent Hartland and the 3 Rs. The only power this board has is to set policy. And this new policy will give the board consequence options for board member ethics, policy, or bylaw violations. We have high expectations of students, staff, teachers, and administrators. We hold all of these groups accountable for their actions. We hold them accountable through policy and bylaw. We hold them accountable in our buildings, on our campuses, and when they represent Hartland schools. If we have high expectations and accountability for students, staff, teachers, and administrators, the same should apply to board members. We all represent Hartland. As board members, we have the same expectations of conduct that we require from everyone else. This policy allows the board to discuss violations at public meetings. If we demand transparency from the district's employees, then we should demand transparency from its board members. If a board member violates a policy, we can add the violation as a discussion item. We can censure a board member. Board members can be removed from committees or officer positions. I would like to remind the public that board member cannot be removed from office by this Board of Education since they are elected. As a Board of Education, our role is not limited to establishing rules. We are equally bound by them. This policy is pretty close to what Brighton has put in place a few years ago. I want to give them credit. This is pretty close to what they have in place for board member violations. So, thank you.
Okay, thank you. Any questions or concerns regarding the proposed new policy?
If memory serves, one of the reasons why Brighton implemented this is that they definitely wanted to get rid of the kids who felt they weren't playing nice with others on the board. And it was essentially a way to try to remove a couple of board members who were up for recall. So I just, in something like this, I just want to make sure that we're not having a policy in search of a victim here. That's all.
Understood. Yeah, I'm not familiar with the origin of this policy or exactly when they created it, but I know it's been in place for a couple of years, I believe, in Brighton, but that's noted. I get what you're saying. Scott?
Yeah, these things, I think Mr. Gogolewski kind of alluded to it. They tend to get political. I would like to avoid that. I don't, these things always come up in an election year. Obviously, this is an election year. A lot of the censures and stuff are used for election and campaigning purposes. I just would like to avoid that kind of thing. That's why you'll note, actually, there's something on here about contacting the governor to have somebody removed from office. Like, that's already law, but it specifically excludes election years. And the first year of someone's term and the last year of someone's term, because it's used as a political ploy. So, obviously, should there be consequences for ethical violations? I'm not opposed to that. I just would really hate to see this get any more political than kind of it already has, so.
So in here, there's nothing that doesn't already exist as an option for a board to do, correct? So for example, board member committee assignments, you can be removed from those, right? And I think in policy 171, under the president, it already grants the
Right.
president the power to remove. So if we're referencing other policies, I would recommend that we include them in this policy, just so that there's consistency, we can tie it back.
So that was policy 0171?
Dot one, correct, yep. And then whether you remove somebody from the officers, that is already covered in policy 0152 officers. It says an officer may be removed for cause by a majority vote of the full board. So I think we've already sort of covered that one. The censure, I don't think we have a policy on it, but I'm somewhat familiar with that experience. So I don't know what you, I mean,
Well, it's obviously
again, we didn't
legally,
have this
it's-
policy
it's-
then, and I know we were able to,
Right, this just puts it in writing, right? It puts it into policy, which is kind of, a recurring theme through our discussions tonight is,
Yes.
get it in writing, put it in policy.
Yep.
So yeah, it's obviously a legal option.
Yep.
But this puts it in writing in policy as an option.
and then again, just for potential cleanup, I would add in the closed session, so in section 2 there, it says board may convene in a closed session under Open Meetings Act. I would actually cite that statute, which is 15.268, section 8(1)A,
I'm sorry, where is that?
number 2. Says the
Whether to remove.
board may discuss an alleged violation as agenda item at a board meeting. The affected board member's request, board may convene in a closed session under the Open Meetings Act. So again, I would cite the statute there.
So in the previous one, we added in compliance with the Open Meetings Act, and we didn't add it there.
Yep, we should.
So, you know, again, to be consistent, I don't have a problem with referring to those other policies. I think that that's fine. I mean, it doesn't change the intent of what this board policy is meant to do, so I'm fine with adding those references.
Well, it also serves as a reminder for future boards, right? If they're changing a policy here, it's a nice quick link to make sure you catch it in both places.
Yep. You have something else, Mr. Scott?
Yeah, I mean, I just think, again, I don't disagree with the general nature of either of these. But I would just like to see a more positive direction. I know we have turmoil, we have strife, we have problems. But we're writing these policies for our future selves and our future board members and our future administrators. And I would just like to see a much more positive tone in general with the ethics stuff. And then it's not, you know, it's looked more positive, more favorable from the community. It doesn't demonstrate, it's not a signal to the world that we have problems and we're going to get to the bottom of them. You know, just again, looking back at the Novi procedures, all of their ethics items are posted in a positive manner. Board members will represent the school honestly. They will avoid conflicts of interest. They will, you know, abide by majority decisions while retaining the right to seek changes in such decisions through ethical and constructive channels. It's saying the same thing, but in a way that I think would be taken by the community and by board members in a much more positive manner. So,
I see this as, I mean, although I hear what you're saying, I see this as a positive step forward. This sets expectations for board members and for the community to know that when there are ethical and policy and bylaw violations, that this board has the ability to take action. Like I said, that is one of the most common things that I hear from people in this community is, what can be done? I didn't like this. What can you do as a board? I get that question all of the time. And I think that this board should have the ability to look at consequences and options for board members who violate. I mean, we have board policy violations in the past, and what can we do as a board? The community deserves to know that we are serious about making sure that we are holding each other accountable for our actions and behavior as board members. I see this as a positive step forward.
no, I agree. What I'm saying is it should be written in a more positive manner. And maybe I'm referring more towards the ethics. But the ethics should represent what we all should be doing to do our job well.
Which I think most of these
does.
actually do.
Not,
It doesn't say will not, it says that they will.
not disrupt or proceed. So if you compare that to, again, not to keep going back to this to Novi, but, you know, will become sufficiently informed, will respectfully listen to those, you know, who communicate with the board, will strive for a positive working environment. I just, you know, if you're reading the two, and this isn't just your changes, this goes to our ethics in general. If you're reading the two, if I was, you know, didn't know either school district and said, hey, geez, I want to get involved, or I want my kids to go there, and I sit down and I look, and one has a list of, you know, 14 positive ethical, you know, guidelines, and the other one is, you know, don't mess with this, don't act alone, stay out of management, stay out of government. It sends a totally different message. So again, I think there's a positive way to go about it. If the board is going to decide as a whole, like, listen, we're going to bury the hatchet and try to move forward in a constructive manner, then I think the policies we pass should reflect that. Again, it doesn't, you know, the violations part, again, it is what it is. I would just like to see more positivity.
Well, Just to add to that, based upon the last 3 years that I've been on this board, sometimes I think that there may be the intention to confuse ethics and opinions. And ethics are one thing. Opinions are another. And I'd like that to be maybe a little bit more rigidly stated. Because, Mrs. Shaw, just like you, I'm asked about how do we get rid of so-and-so and how do we get, why? Because you don't like their opinion? Not going there.
And this has nothing to do with opinion. This has nothing to do with freedom of speech. You can say whatever you want. You can say whatever you want about this district. You can say anything you want on social media. This is about policy violation and bylaw violation. This is not about violating people for their opinions. You can say what you want, but that doesn't mean you're free from consequence.
Oh, agreed.
Like our
Yeah.
students and our staff, they face consequences for making poor decisions or things they may say and do. And that is the same thing that I think that this community requires of us to hold ourselves accountable for consequences. This has nothing to do with opinion. Nothing we put in place in a policy at this table is going to change anyone's opinion or how they operate outside of this boardroom. That's not the expectation. The expectation is that when there are violations of board policy, board bylaws, and ethical violations as outlined in the policy, this board has the ability to instill consequences on that board member.
I like the
That's
way
it.
you said that. Yes,
That's
when
it.
there's a violation of policy, when there's a,
Correct.
yeah.
It's not about opinion, it's about fact. All of the things that I read before about policy violations, and all of those are facts. We're not talking about opinions. So just to make it clear, this is about, and it's clearly defined in the previous policy about what is considered ethical, and board policy and bylaws are included in that as well.
Okay, thank you. Any other questions, concerns?
I mean, just to follow up, of the 1, 2, 3, 4, 5 changes, 3 of them use the word not. So again, that's where I'm going. I'm looking for the positive, not the negative.
Sure.
Our ethics are mostly written positive to begin with. And I'm backtracking to the previous discussion, but I'd like to find ways to say this in a more positive manner.
Okay. Mrs. Shaw, is that something that you would be willing to take a look at, where we have a negative word?
Sure.
See if there's a way to reword it so that we can put it in the affirmative?
Yep, I can give it a shot. Sounds good.
All right, and then, Greg, I've got you on for item E to reword that bit about not in isolation.
And then for this, the new draft policy, .5,
Yes.
we will add the policies that it's referring to.
Yes. 171.1, 152.
The Open Meetings Act, we can refer to
Cite the
those
statute.
policies.
Okay. Anything further on the ethics policies? Fabulous. We're doing pretty good on time. All right, so next up is 3120. Give you a little intro on this one. Nope, sorry, communication. It's communication. Thank you.
Yes.
I accidentally crossed that one off.
Just, this is here nor there. Ms. Shaw, you had put 0144.5 as this policy. Just so you know, it's going to depend on Neola to assign the exact number, so
I think I got that number from Renee,
you
maybe?
may have, but we
Or
just,
or you, but,
I just want to make sure you know that Neola might have a policy out there that's that number, so.
Okay.
I would just leave that as question mark for now. I don't want anybody to come back and go, well, we can't adopt it because I thought it was policy 0445, so,
Thank you.
okay?
Good call.
That's clerical.
All right, so this is the new proposed policy, communication. This policy draft was a result of a productive discussion, as I understand it, among Mr. Hughes, Mrs. Gregory, Mr. Keller, Mr. Gogolewski, and Mr. Campbell. Following one of our last regular meetings, this was a follow-up item. I believe it was our admin team, correct me if I'm wrong, that provided the original draft. And then, Mr. Keller, you provided some input with some suggested modifications. I'm not sure exactly of the process. So how about if I kick it over to Mr. Hughes or Mr. Keller? Let's do Mr. Keller. Can you maybe give us a little more context, clarify the process you guys used, and just give us a little more idea about what's behind this?
Yeah, thank you. So the purpose, as you mentioned, right, we had some follow-ups from the last meeting to try to address just general communication and what are the expectations, not necessarily ethics if we go back to the past policy, but how can we improve as a collective group on communication in terms of setting expectations, both, two-way, three-way expectations, right, between superintendent to board, board to superintendent, community to board, board to community, those kinds of things, right? So sent out a framework to the team, and I think, as you mentioned, it was a pretty productive meeting, I thought. We got input from all members, and I think overall resulted in a pretty good first draft of a policy that is aimed to improve communication. Following the meeting, based on the updates that I think the admin team worked on, I had sent out some additional ones that I'm asking the group to consider. I don't think they are a detriment in terms of changing the meaning of anything, but more to sort of clarify some expectations that, I had. And, I want to, again, thank everyone for their participation. Some of them I would kind of look at as rather minor. For example, right, page 1, just in the spirit of following the format, there was a previous header in there that we kind of agreed wasn't a good one, so we took that out but didn't replace it. So I was asking that maybe we either put a header back in there, something like urgent updates, or, maybe we just pull all those out altogether so that, again, the formatting kind of aligns throughout the entire document.
I don't understand. Are you talking about underneath superintendent communications with the board, adding a header that says urgent updates?
Yeah, so if you look at page 2, it says regular updates. Item 3 is formal reporting. Number
Oh, I
4,
see.
response, so they have a subheader.
So the subheader should be urgent updates.
I'm making that as a recommendation, again, open to suggestions.
I guess that makes sense since you have 3 other types of updates.
Yep, so either I would recommend we take all of those subheaders out or add urgent updates to those. So that's one. And then the other was currently under H, it was intended to be sort of the catch-all of anything that's may cause community concern. One that I wanted to add in there that I missed when we were having our subcommittee discussion was any legal updates, because I think, we've experienced some, legal issues, right? And I think we want to make sure that we have that in there. Just again, I think all that are on the team now understand that, but again, for any future individual that may occupy that seat, that they have that clear understanding that legal updates would also be included. So again, I'm recommending that we,
What would you define as legal updates? Are you talking about like that
well,
the district?
hypothetically, if we settled a lawsuit, we would want to know.
But, we get legal updates from some of our attorneys' offices. We get, Mr. Hughes might get a legal update about a student issue that wouldn't come to the board. I think, I'm not sure legal issues, maybe we need to be a little more specific about what that looks like. Because he could have a lot of legal issues that come across his desk, but that doesn't mean that that would come to us. Do you know what I'm saying? What if it's an employment
So-
legal issue that we would not be involved in?
So I guess what kind of boundaries would you want to apply to that? I hear what you're saying, but I left it legal because without listing every single possible.
Right.
Right.
I don't know, Mr. Hughes, I'm sorry, President Coleman, can we ask Mr. Hughes to maybe offer some
Mr. Hughes, if you've got any
opinions on
thoughts
how
there.
to quantify the legal?
So I got a simple solution. I like flexibility. Legal matters is good enough for me. If we think it's gonna be something that you're gonna see, like I hate to start putting lawsuits and being threatened to be sued. That happens periodically. This and that, like legal matters. If there's something coming down the pipe that you all need to know about, yeah, I agree that we should let you know. So I think legal matters covers it, and that tells the superintendent, whether it's me or a future superintendent, hey, there's a legal issue, you need to follow up. And certainly, as we've said in the past, if you ever hear something, you have questions, or, I've shared a legal matter with you, and you want to know the outcome, and you haven't heard anything, just call me and I can fill you in, so those types of things. But I think just leave it legal matters. Can I go back to the urgent one? Can we just put it next to superintendent? So urgent superintendent communication, because later in the packet, you suggest urgent under superintendent communication with parents and community. Just put the word urgent next to each of those. Is that good enough? Will that work for you? Instead of updates, just urgent communication?
Sure.
All right. All right, now we can keep going then.
Okay.
I'm sorry, hold on 2 seconds. So you're saying just add it to the header? Add urgent
Yeah,
to?
I'll just put urgent next to urgent superintendent communication with the board.
Okay.
Check that covers that whole section. And
Yeah.
you have like regular updates is number 2. You have,
Oh, yeah.
Okay, so it should be above one?
Yeah.
All right,
yeah, with 1.
okay.
Oh, yeah.
And a round of applause for whoever put the page numbers on here.
You're welcome. All right, so.
Let
I'm
me just
sorry.
ask, just a process question, because I have a couple of smaller questions as we go. So should I address those as we go through, or do you want to get through your
No,
stuff?
it probably makes sense. Why don't we, rather than go out of order and jump around?
Okay.
If anyone has questions or contributions, I'll stop now, and we covered through item 1, I guess, on page 1.
Yeah.
So everything through item 1, page 1.
Okay.
How about we stop
I
there?
may have jinxed us when I said we were doing good on time. And I know that, so Chuck, you and your team have had input on this as well. It just, I felt it was too broad maybe, but maybe you're okay with this. Item D, so item 1D, it says any financial concern, and obviously it gives an example, but I guess I didn't know if anybody else felt that was too broad, like to say any financial concern, or if we wanted to be more specific. But again, I wouldn't know how to define it.
Can we ask Rachel? Rachel, when should we notify the board, like on a financial concern? We have in there missing or unaccounted funds, which we've had a couple instances.
I mean,
in our-
that to me is the financial concern. I mean, I off the top of my head, I can't really think of what else would be. I mean, I always have a financial concern
Right.
every day.
I mean, that's what I was thinking. So are we going to get a message
That's
from
your
Rachel
job.
every week?
Every day. I
I'm
don't
concerned
think you want an
financially.
Email from me, so,
How about any unusual financial concerns
yeah, and I think,
or unusual financial concerns?
can I think about a good word?
Yeah.
I mean, I think it's pretty much covered.
I mean, if
in
you
the-
guys are comfortable with it, then
Like,
then
I'm
I'm
comfortable
okay.
with
I
the way
just,
the example reads.
it just caught my eye as something that
One
might,
example I could think of is, let's say, Title I, Title II, Title IV grants all go bye-bye. We just get hammered with that, and that's thousands and thousands of dollars that we would have an issue that probably you would have to know about.
sure.
But-
Yeah, and I think that would come across in like a budget amendment or.
Sure.
Like, I don't know if it would warrant a separate communication necessarily unless it was, major, but that's kind of part of how that would kind of fall out.
Okay. Okay, I'm good with the other ones that I had noted.
Okay, so I'm going on to item 2, regular updates. We already get weekly updates, and I would prefer that we keep that way, so I was gonna remove bi-weekly.
Well,
Sorry. I'm
No.
okay with that, but except when school is out of session.
Yeah.
Because Chuck doesn't necessarily provide, well, I guess this is just to the board, but, I mean, I
yeah,
don't
you'd have
do
to
you?
clarify, I do the weekly updates to the parents, but you guys get my update it's usually every 2 weeks, but unfortunately, the last 3 weeks, there's been a lot of things to share with you. And so, I hate to just try to put something together if there's a week there's really nothing to share. So that's why I'm saying, to me, weekly or bi-weekly at least, to let you know what's going on. I would hope that you can accept that. I don't want to just send you something, just say,
Right.
hi, this is my weekly update, everything's good, like that.
I think I'm fine with leaving bi-weekly.
Yeah,
or
or
on
I'm on
vacation.
vacation that week or
Right.
whatever.
I think bi-weekly makes sense.
If you can
So
accept
we're
that, I'd
leaving bi-weekly?
I'd
Okay.
appreciate that. Thank you.
I can accept. I guess I'm giving you more credit. I thought you were sending them every week, and I never even noticed. But it just felt like we were always getting them, so it was a compliment. Okay, so that covered, I think, page 2. The page 3, top one there, again, this is, now we're in the board communication to superintendent section. So as a public spokesperson role, I think in our policy, we sort of already identify the president is the public spokesperson. So again, in the spirit of aligning all these various documents with other related policies that say the same thing, I wanted to add that in there.
But I know we've talked about a few other policies that, this is a repeat of a policy we already have. Do you think it's necessary to repeat it here, even though it's in policy already? Because we just had that conversation a few times tonight.
Yeah, I mean, if we do it for ethics, do we do it here? I think that rather than being half pregnant.
Craig! We can leave it. I don't know what else you're going to say.
I think it's fine to leave
Yes.
it. We might as well be consistent, I guess. So if we added the policy notation
Yeah.
in the previous policy, I'm fine with adding it here. The cross-reference is fine for me.
All right. All right, number 5, about the information request, and I know we talked about this one in the previous. Initially, it was in there, but after giving some second thoughts to maybe some ambiguity around that. So if a request requires significant staff time, must receive a full board consensus vote before proceeding. My concern is that there's not enough definition around significant and what that means. And so my concern is that everything would have to come to a board vote to decide whether or not an individual could have information.
I think we could leave that determination up to the superintendent. Because again, not acting in isolation. I can't ask Mr. Hughes for 50 years of data individually. I think significant staff time would be up to the superintendent to determine. We leave that decision up to him. What is significant time?
Can I ask, what was the context in the conversation, in the meeting? Did you guys talk about this specifically? I'm just wondering, what the discussion was around it.
What's the context?
Well, again, extreme example is if somebody asks for something that isn't related to anything that you're dealing with on the board, and it's, 6 years worth of data collection to get it, then it would be something that would come before the board. But I think there's a lot of gray of the area in between, and that's where I'm concerned that everything would come back as a request of the board to compel.
Are you looking
If
to
necessary.
put a quantity of time, 20 hours, 50 hours, 100? I don't know how we would determine, unless leaving it up to the discretion of the superintendent, what would be significant. Please.
From the superintendent perspective, I think here's where we've found the issue over the last few years, and that is, a board member has a question, and normally how it works is a board member comes in, asks their questions, we say, hey, this is why X exists, or this is why we do it this way. And most of the time, a board member will say, okay, great, good information, thanks for sharing. But what we found in the last few years, unfortunately, is here's the answer. Okay, now I don't trust you, it feels like. I don't trust you, so I want you to give me all of this other information. I want you to dig for the last however many years, and I don't really care how long it takes you. I want this information. And I say, wait a minute, what does it have to do with the specific job that you're doing at this point in time or the decision you're making at the board? And if it doesn't, I say, it's not fair to my staff and my team to go digging, or myself to go digging for information that really, I've just given you the history. How come that's not good enough? And so, I think if board members want to ask for information, I think it's fair. And information that's pertinent and information that's easily available, I think that's fair. It's when it gets into the nitty gritty and then we go down a different road, and that always sucks too because it ends up coming to the board anyway. So that's why I was willing to accept that language when we talked. I thought that was good language.
Leave it as significant time?
I just thought significant is good, and I think I can explain to a board member what significant time looks like.
Okay.
So that's just my thought process.
Yeah, I would be in favor of leaving that sentence.
I would too.
Yes. But can you say, though, like, what is significant? I mean, can we just put that in print now? Or give thought to it before the next meeting? And, I mean, it's case by case, I guess, or the nature
Right.
of the request. I don't know if that should really matter, if it's validated request or not. But if you say, it's 4 hours or more to dig into this, or 2 hours, and then it's up to us to vote, but significance kind of ambiguous. We try to get away from in this policy. So if you can narrow down the time and.
I'm okay for you guys to decide what that hour should be. Like, at the end of the day, the district pays everybody's salaries. So I'm good with 2 hours. Like, that would be good for me, but it may not be good for the board. But the reality is, what we ask the board to understand is, we do have jobs that we do every day, and we're constantly trying to get the job done. And when we're sidetracked to go digging up all this information simply because somebody wants it, it's not fair to us. And so if it's 2 hours, if it's 4 hours, if it's 3 hours, like, I don't know. Like, we still get in the argument of, well, who's estimating the time frame, right? Well, I'm estimating it's going to take, if you want all this stuff, I called Rachel and said, Rachel, how long will it take you to gather all these documents, POs for the last 5 years? And she says, geez, Mr. Hughes, that's going to take my staff 10 hours or more. I mean, that's unreasonable, right? So reasonable to me is something that is technically a document that's created, that's sitting there, that's not a problem. Board member, if you want it, we have it, there it is. But if we have to go looking for it and gather it up and put it in a form that you want it in, that takes time and energy. That's my concern. And so again, when we met as an ad hoc committee and that language popped up and it was suggested, I think it was in a document that you presented, Greg, I'm like, yeah, that's fair.
Yeah, again, conceptually, I think it's fair as well, but kind of going back to our conversations on FOIA, it was like, well, if it's over a certain number of hours, we should pick up the phone and call them, not give them.
Right.
So again, it was sort of a second consideration of the process that made me question whether we really want to put that in there, or if we should at least add some context around what is significant.
Can we put 3 hours estimate? I'll just throw that on the table. You asked Mr. Campbell, I'm going to say estimated, it's going to take 3 hours or more to do it.
Yeah, 3 or more, and it's not saying no, it'll just come to the board
Yeah.
for vote.
Can I throw something out there? If you ask me during grant season or testing season, 3 hours is going to be a lot.
That would be significant, right?
That's significant for me during certain parts of the year.
I mean, that's my concern is, again, we always have the option to bring this policy up for discussion down the road if we think that significant is 5 minutes when we think it should be 3 hours. I think that's the hard thing, right? Like, I think it might be situational, depends on the time of the year, or who's on vacation, or, I don't know. I think quantifying a number. Yeah, I think there's too many variables to, again, and who is the staff member? What if it's budget season and then Rachel needs to spend 10 hours, or even 5 minutes might be too much. I think that's my concern with putting a number there. I don't know. It's just my
I
2
think,
cents.
I think too, the other reason why this appealed to me when it was presented at the ad hoc committee was if I say, really, what does that have to do with the decisions you're making as a board member at the table? At least it forces the board member to say, if this goes to the board, how do I make my argument that this is pertinent information that I want the administration to spend time digging into it to get it to me? So therefore, significant would be enough for me to say to the board member, that's going to take some time. That might fall under this category. Maybe you have to explain to the board why this is so important for us to drop everything and spend whatever time it's going to take to get it to you.
So could we add some clarifying words to say, if a request requires significant staff time, considering a variety of circumstances such as testing season, grant season, financial reporting, or, something like that, we could list, at least a few examples of considerations that we should take into account to determine the significance. And then, because I agree that if it's that busy season for Dave and there's a curriculum issue, we have a pile of data that we're asking for, or that somebody is asking for of Dave, he can't do that necessarily during testing season. It's like there's no time on his calendar to look into something that's going to be a 3-hour project, even a 2-hour project, which would fall under that 3-hour threshold. So, to put a specific number on it, I don't know if that necessarily is the best solution, but maybe some clarifying words to say that we need to consider a variety of circumstances such as.
It seems to me like, why can't there just be some communication with this? Like if somebody wanted something from me, I'm going to get it. I may need to tell you it's going to take me some time because this is going on, and we just work out a time where I can get it to you and work it out. It just seems like it'd be easy to work out without putting a number on it, but say, okay, Dave, I'm looking for this, this, and this. I can get it for you, but it's going to take me a week to get this because this is going on right now, and just go through that conversation.
I think it takes into consideration that you have jobs to do, that you have, students and meetings and deadlines and, and.
Because I'll never say no. I mean,
Right, you never have.
I'll do it.
Right.
It's just, putting a number on it kind of pigeonholes it a little
Sure.
bit.
Don't ever say no, because, things do happen where, seriously, I think it's contingent upon. Yeah.
There you go.
And I think it's okay to try, but when it's unreasonable or it's going to take a lot of time, I think, and it has nothing to do with the nature of the decisions being made at this table, I think that is a concern. And so I guess what I would ask is if, Ms. Coleman, if you would like some clarifiers there, if you allow my administrative team to meet, talk about what that clarifier could be, and then Greg, I reach out to you and run that by you. Would that be okay?
So are we saying this only applies to issues that are not on an agenda or future agenda for discussion or vote? I guess my concern here is relevance, and so if we, especially since we're getting better, but sometimes we don't know what's on the agenda for vote until, Thursday before a Monday meeting. And so if we have questions or we're asking for information needed for a vote, then can the superintendent just say, no, it's going to take too long? You have to vote on it as a board. Well, now I have to vote Monday. I'm not going to be able to have a discussion at the board on whether I'm allowed to see this information for another month. Well, the decision's done and gone. So, I can give some recent examples, but.
I would think if we don't have that information at our Monday meeting, we would vote to postpone that matter, maybe. I think too, Superintendent Hughes, when you speak with your staff, if we stick with 3 hours, if that comes to the table to decide if it's worth the time, we could also say, Mr. Minsker is saying, I'm very busy right now, whatever it is, and we say we could also consider a timeframe as well, within a reasonable time that's agreed upon during conversation. So it's not, then it's just not left, it's over 3 hours, but we do want this information, and then we leave, and 6 months later, we still don't have the information, so that way, both sides have an understanding when that information can come in. And again, if it doesn't come in, to your point, Mr. Scott, I get that, Thursday for the Monday vote, then we just bring that up for discussion Monday at the meeting and discuss that and figure out how to handle.
So how do you see that playing out? A board member would just say, I've requested information pertinent to this vote and not received it. And I guess just move to postpone it.
Absolutely. If you're one of 7 that feels that way, then the majority is going to move forward, but state your case, just like we're talking about doing in this instance, and hopefully it's postponed so we have all the information that we need.
Fair.
Okay, I know we're getting close to the top of the hour, so let's, number 7, I think kind of in the spirit of the previous policies we looked at about not being in isolation, so if there's one board member engaging with the superintendent, and I think Mr. Hughes kind of does this a lot of times anyways, but again, let's do what let's put it down there since that's what we're doing anyway, so bring the rest of the board into a discussion that you may have had with another board member.
I agree.
Again, to
I
try
think that's a good
and
idea.
improve the communication,
Yep.
so.
Okay.
No issues there.
And then the last one we, I think, already covered, which was just to make the subheader,
Yep.
I think,
Urgent. Yep.
urgent. And I believe that covers everything
Right on time.
for
Unless
that
there's-
one.
Let me
Is
see,
there other
hold on.
people?
I had a couple notes. Let me just see if it's something that I need to ask. One was a typo, so I can talk about that later. Just a question of, again, of the context that you guys had in the conversation. The items that are under this section that goes from page 3 to page 4, superintendent communications with parents in the community. Was it understood, did you guys talk about the fact that most of these are covered in Chuck's weekly updates to the community? Like, was that, I just want to make sure that somebody actually said that out loud, that, these items are actually covered. A lot of them are included in those weeklies. I wasn't sure if anybody noted that, but, because a lot of them I thought were.
Yeah, I
Yeah.
think so.
I noted it, and the reason why I was okay with it and didn't have any issues there is that, this
You're doing it
could
anyway.
create a checklist too, right? For that update, just to make sure, right?
Okay. And then just one last quick thing, sorry, 2. Number 3, timely and proactive updates. I know it's redundant, but provide regular notifications, but that doesn't necessarily apply to things like curriculum updates. There's no regularity to them per se, so maybe just timely, repeat the word timely
Okay.
from the subhead instead of regular.
Yeah.
Feel me?
Or even just provide,
I mean, because I like the notion of
Patients?
keeping the temporal limit there, right? Having something that describes that, but not necessarily regular, because you're not going to get a curriculum update every week.
Yeah, I think that it was really, there's some things that have a certain cadence with them all the time.
Sure.
Like, we approve the curriculum manual, at this time of year, we have the organizational meeting, things like that, so.
Okay.
I think that was just the intent, but certainly if there's some heartburn with that, I'm open
As
to
as
change.
long, again, I wasn't part of the discussion, right? So I just want to make sure that you guys talked about it and that it was, if you guys are all comfortable with it, I am. I just wanted to bring it up. And then, has legal counsel reviewed this? Have we run it by legal? Okay, so we'll need to do that before we can
I
enact
did
it
not
as
ask the
well.
president to do that.
Understood. I wasn't sure if Chuck had done that, so.
I had not.
Okay. All right. Okay. Anything else with 3120? I know we've gone a couple minutes over. Thank you for bearing with me.
New policy?
What's that?
new policy, not 30.
This is no number
Oh, that's right. This is
policy.
No number.
communication. This is communication. So,
But you had a number, is that also just a placeholder?
It is. Okay. Don't tell anybody.
Chuck just
It might
likes to make
change.
up the numbers. Okay, so yes, this was new policy communication. So we have left off with 3120. we all agreed that we wanted to stop at 9. It's 9:03. Are we in agreement that we can carry over 3120 to the next policy committee meeting and put that on the agenda at the
Well,
top of the agenda?
Yeah.
I don't know, can I address that?
Sure.
So before I do, with 1410 and 141001, so am I correct, building administrators are not in this right now? So building administrators will not be addressed this month?
Building administrators contract, they're not in 1410. Remember, they were pulled out when we created the union contract?
Yeah.
The board has and will get to vote. It's going to be an action item in February to approve their TA that was created. That TA then, as we've traditionally been doing, and we said when we did this with them, is that anything from there would be carried over to 1410, right? And so in 1410, 1410-01 reflect changes that would be applied to both, to be fair, to these administrators as well as these administrators. So
What would be applied to both?
I believe you got a copy of the TA, work from home on the next 4 snow days and the 422 percentage increase that we TA'd. So
So you're saying 1410
we'll reflect that.
reflects the TA with the administrators
Correct.
union?
Exactly.
Okay.
Yep.
So, all right, so that kind of gateways into the 3120, and I'll just kind of,
Are we doing, we did say
Well-
9 o'clock.
yeah, well, I'm just going to state my case for whether or not we can delay it for another month, I guess, based on President.
Everybody's okay with sticking it out for. If everybody's okay with sticking it out for a couple more minutes, I'll
So-
give you a couple minutes.
The reason I had flagged 3120 is because we have created the administrators union since this policy was, not we've created, but we've approved, and they've created the union for the building administrators. And like Mr. Hughes just said, the central office administrators are not included in that agreement. I think 3120 has maybe not been modified to reflect that change, and I'll kind of give you an idea where I'm going here. My biggest concern, and this goes back to communication, is making sure that the board can remain informed about changes in the central office. And we've seen over the last few years where the superintendent, through contract, has the ability to move building administrators to the central office without notification or approval of the Board of Education. And I just want to kind of open this up to see if that's something that we as a board are comfortable with. You know, we could literally show up to our next meeting and one of these seats be filled with somebody new, and we never knew it was going to happen. We were never notified, we never approved it. And, you know, that is of concern to me. The current the current policy 3120 dictates that personnel need to be approved by the board, but then the administrative contracts kind of override our policy and give the superintendent the ability to transfer. I don't have an issue with being able to transfer within the building administrators. I guess my issue now is that we've separated the building administrators from the central office administrators. It doesn't make sense to me that now the superintendent has those same transfer powers. I want to stay informed about central office leadership and make sure that we have a fair, open process for filling any vacancies. Right now, vacancies can be filled without posting a job, without doing interviews. It's a simple appointment. And if anybody works with any public institutions, they know that's generally frowned upon to avoid cronyism, nepotism, all those sorts of things that lead people to believe there's not a fair process in place. I think as a public institution that employs, 500 people, or it's important we have processes and standards in place, especially for our top leadership. We've seen jobs, again, This is not personal. I know people are going to take it personal. There will be things taken out of context. This is not personal. This is about setting policy to make sure we have the best protections in place to ensure the academic success of our students. And posting openings is the first step in that, I think, especially with our top leadership. So I think there's a gap between the changes we've made in the administrative structure, in the creation of the Building Administrators Union, and current processes.
So you haven't made any, what suggestions are you making we've changed it to this policy? And again, we are not part of the administrative team. That does not fall under the purview of the Board of Education. We
Correct.
approve, but until the approval process, not the Board of Education. That's the superintendent's office. So what changes are you suggesting to this policy?
So we approve new hires. What we don't approve is transfers, right? So
If you don't mind, can I have a minute? Yes. First of all, there's not a single central office administrator or a single administrator in this district, even under the contract. Article 5 of the association's contract, the board still has to renew yearly annual contracts and extend the annual contracts, which will come before the board in March. So Article 5 in their contract clearly outlines that the board still has to approve their contracts. So anybody that's sitting at this table, the only way they're sitting at this table is the board has to approve a contract. That contract comes before the board based on 3120. It says the board shall approve, such approval shall be given only to those candidates for employment recommended by the superintendent. So we work really hard in this district to build leadership capacity. I put all this in writing to the board. You all have this. I gave you a list of all the administrators that have come through the ranks here in Hartland and makes Hartland a special district. And if we feel like we have a really good candidate to fill a position, then we're going to go forward with that candidate because it's in a good position for this district for a couple of reasons. Number one, they know the culture of this district. They're not coming in cold having to learn it. They know the history of this district. They have relationships with people in this district. And so I would say Rachel, who came up through the accounting office and is now CFO, myself, who came up through the building principal, assistant superintendent, now superintendent, Ms. Gregory, teacher, and Medina student, administrator, principal, came over to central office, approved by the board, by the way, the contract, and Mr. Minsker came in as assistant principal, was around elementary principal, high school principal, and then assistant superintendent. We have really good people, and the list goes on, as you have in front of you that I sent you today. So at the end of the day, you hire me, the superintendent, to manage this school district and to keep the district moving forward. I make recommendations to you. If I make a recommendation to you, regardless of how I get there, I may not choose to post it. I may not, we post sometimes. Misty Gunn, Creekside, we posted. We didn't have somebody we felt would go over to Creekside. We posted it. There are a number of other people that we posted because we didn't think we had built the leadership capacity to be able to handle that position. So at the end of the day, I'm going to recommend somebody to the board. You get to choose to approve the contract or not. And if you don't, then I have to tell that person, thanks, but the board did not approve your contract. And I have that conversation with that person every time. I would have had it with Rachel, I would have had it with Kate, I would have had it with Dave when I brought them to central office in the positions that they're in now. So
the process you're describing is not what has actually played out. So that's my issue.
I think it is.
So when the DEI's position was created, what was that called?
Student support services.
Student support services. When that position was filled, is it your contention that the board voted on filling that position?
It's my contention that the board had created the position in 1410 and that I had the ability to fill that position with a need. And the board allowed me to do that because it was part of board policy, the position is available.
And our approval was the approval of her contract.
No, it was not. Absolutely was not. I FOIA'd this before I was on the board and was told no such thing existed. Mr. Hughes explained to me at the time very clearly that he has no need to run approvals by the board if they're currently employed with the district. He can put anybody in one of these 3 seats without even board approval as long as they currently have a contract. That's how it was explained to me. That's how it's been carried out. My wish is to do it exactly as my wish is to do it exactly as he's described. But the current administrator's contract allows for circumvention of 3120. So that's why in my note, I did say this is probably a 2-step that we're addressing both at the same time. Now, the building administrators union agreement says that he has the ability to transfer principals from building to building, job to job. That's fine. I don't have issue with that. My issue is when we're bringing administrators into the central office and those decisions do not need to be brought in front of the board at all. I have an issue with that. Again, this isn't personal. This isn't about any one person getting any job. It's about not keeping the board informed of the job openings and the succession plan, if you will. And so according to the administrator's contract, like I said, any one of these positions can be filled tomorrow without us being notified or without us voting on it. And that's how it's been conducted. And if you want to search the history on it, please do. I can assist with that. But the board did not vote to approve the new contract for the DEI position. The board approved to create the position. That it was presented to the public as if we're creating a position and we're going to go find somebody to fill that position. And in the middle of the night or the next morning, a new contract was signed without board approval. That's what I have issue with. That's what I want to avoid going forward.
For whatever information you have, I can assure you that the entire board at the time in which that occurred were aware that I was bringing Kate over.
It did not come across the board table. You have used the aware of.
Yep.
That is not how boards work. It has to be discussed and approved at the board
So maybe this
table.
will help you, Mr. Scott. Here's why I can assure you, I'm saying it in public. Whoever I bring to central office in my time as superintendent or the next superintendent, the expectation is that when we bring the central office, you are aware that we're bringing the central office and you'll have a contract to approve. And that falls under this category of you shall use my recommendation as a superintendent hired to manage the school district as the emphasis for whether or not you approve the contract or not. And that'll be your choice as a board.
But my problem is, as I stated, that we create contracts that circumvent policy. I think that's an issue. When we look at contracts that are coming up, I think we need to make sure that the contract is in line with policy, not circumventing policy. Right, and that's why I did ask you to share with the board the administrative contract that you're going to present, in March?
It's online.
No, I understand. But so everybody can see that we create contracts to circumvent policy. And that is a detriment to this board. And so that's what I have issue with. If we, the policy on its own is not the issue, it's creating the contract. So if I was going to make a change, it would be to require the board approval in the contract and in the policy, not giving the loophole in the policy for the superintendent to make decisions without board approval on those central office leadership changes. Again, I have no issue moving around principals, and that my issue is showing up to this table and there's a new face in a central office administrator position that none of us knew about.
Sure. Understood. I guess next step here then, if there are words that we could put into this policy then that would address specifically your concern with bringing it to the board table for a decision, or if is it something that becomes part of this communication policy? I mean, there's already a letter, a number or something in this communication policy where it says extended staff leaves or administrative staff moves. I mean, it's already, I mean, maybe we expand that, and maybe that addresses your concern. So I guess I'm having a tough time figuring out where exactly or how exactly to spell it out to address
Yep,
your concern.
I understand. It's an expectation that the board's going to be kept in the loop, that, you know, as I said, the way Mr. Hughes described it is fine, but that's just not the way it's played out. And if anybody can find me meeting minutes to contradict that, I'd be happy to look at them, but I
Sure,
don't believe they exist.
And the example that you've presented, that I'm sure that is exactly how it played out the way you specified. But that is one case. And I think the other cases that I have been a part of when I've been on this board have gone the way that Mr. Hughes has expressed it tonight. So there's at least one case, sure, I'll probably give you that, but it's the issue, I don't know if it's a process issue, if it needs to be spelled out in a policy versus a process, if it can be addressed in the communication policy that we just discussed. If you can find words
Yeah.
to make it make sense and make
and-
it palatable.
And also, I think, again, and I've asked Mr. Hughes if we've had any recent legal review on the administrator contracts, but I have issue with contract language that circumvents policy. So that's the other issue, and we will be looking at those contracts here in March. I don't want to be having the discussion in March. You know, I don't, obviously, you know, we can't make a decision, but I want to renew contracts with administrators and give them the pay raise they deserve. I don't want that whole process to be held up because we have contract language that we haven't got legal opinion on, that we can't agree with, that we think circumvents policy. So I think it's a multi-step policy
Okay,
process.
so, Mr. Scott, I sent you a blank copy of, like, soon,
Yeah.
not the day before the next meeting, like soon. If you have a problem with some of the language in there, send that back to me. I will give it to Thrun, and I'll have them review it again. They just reviewed it 2 years ago and said it's good.
It says board approval or superintendent discretion. So my request would be and.
Okay.
So that way we're ensured it hits the board table. I'm not trying to micromanage. This is about being informed about the central office leadership, which is the most important component of making sure our students receive a quality education. And it gives each and every one of us an opportunity not to be surprised by middle of the night staff changes in the central office.
Anything but central office is what your concern is.
Yes. Yeah. Well, we already have an agreement with the building administrators. I have, again, my intent is not to micromanage. The issue is the people who sit at this table with us and are engaged in conversations and are making policy recommendations. I think it's fair that those people come across the table for approval, just like every teacher and everybody else in the district.
Okay, thank you. My apologies to all of you guys for keeping you for another 22 minutes. But at least we were able to hash out some of that. Mr. Scott has a follow-up item to come up with some words to put around that, and we'll figure out if it belongs in communication policy or in 3120, or where the best spot is to put that. All right, so thank you, everyone, for your patience, for your contributions. Much appreciated. That's mine. We are adjourned at 9:22. Thank you.